2017 meeting of the Municipal Code Enforcement Board to order. If all would stand, we'll have the Pledge of Allegiance, please. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. I'll start with the general announcements. The city desires to accommodate persons with disabilities. Accordingly, any physically handicapped person pursuant to Chapter 286.26 Florida statutes should at least 48 hours prior to the meeting submit a written request to the chairperson that the physically handicapped person desires to attend the meeting, and accommodations will be made. Any person who decides to appeal any decision of the Code Enforcement Board with respect to any matter considered at this meeting will need a record of proceedings, and for such purpose may need to ensure that a verbatim record of the proceedings is made, which record includes the testimony and evidence upon which the appeal is to be based. Any person or defendant who requests to review or object to any exhibits presented to the Code Enforcement Board by the City of Titusville prior to submission to the Code Enforcement Board must stand and state their requests to review the exhibits prior to review by the Board at the time that their case or agenda item comes before the Board for hearing. Any person found to be in violation of the City of Titusville Code of Ordinances and given a time frame in which to comply shall, upon compliance, be responsible for contacting the Code Enforcement Supervisor for an inspection to verify said compliance. The violation will not be considered to be in compliance until a Code Enforcement Supervisor is notified and verifies compliance. Okay, we have 7 members present today. Mr. Rogers, would you like to swear in the staff, please?
Swear or affirm that the testimony you shall provide to the Code Enforcement Board shall be the truth, the whole truth, and nothing but the truth? Yes.
Would someone like to make a motion regarding the minutes of the August 14, 2017 meeting?
I would like to make a point. In this meeting of August 14th, we discussed the water shutoff, and we discussed it. We'd like it to be considered at our next meeting, which was canceled because of the hurricane. Since this is the next meeting, I didn't notice it on the agenda.
Good point. All right, we will bring that up at the end of the meeting then.
Okay. But it's not included in the minutes where we discussed it.
Okay. Anyone want to make a motion, or you want to defer it until the end of the meeting?
Can you make a motion considering the change, adding the change, or would it be better to wait?
You can do it either way. I presume, hearing nothing else in dispute, that the minutes are otherwise acceptable as drawn?
Yeah.
I would recommend approving the minutes as drawn with the exception of the lack of an agenda item for discussion of water issues.
So moved.
Second.
Motion is made by Gina, seconded by Joe. Any discussion? Roll call vote, please.
Vice Chairman Bell?
Yes.
Member Richardson?
Yes.
Member Edens?
Yes.
Member Beckles?
Yes.
Member Grant?
Yes.
Member Monis?
Yes.
Chairman Cunningham?
Yes, motion carries. We will start old business.
Mike, you didn't do a roll call with us, so do we have to, since everybody's here?
Do what now?
You didn't do a roll call vote on us, as us being here, but since we're all here, do you have to do that? I mean, is that?
No, I declare that there were 7 members
Okay,
present.
all right.
Good afternoon, Board, Chairman.
Good afternoon.
I hope that everyone survived Hurricane Irma well enough, and welcome back to regular business here. The first item on your agenda today is case number 16-89 for the property located at 503 Cheney Highway. This case, at the last presentation, I received a question regarding how many times this case had been presented to the board, and I can go over that information after some information is presented to you on this case. I have that for you. I have Brad Parrish here from the city's planning department to provide some testimony. I'd like to invite him up to the podium. This case was previously presented and had an order to correct date of June 12, 2017. And as you're all aware, this case is regarding property that was improved without a permit for the improvements on the property. And at the last presentation, you heard from the applicant and staff saying that a completed site development application had been submitted. However, no permit has been issued to date. Brad Parrish is here to provide that testimony. Mr. Parrish, can you please inform the board whether or not any information has been turned back to the city after the city issued its comments to the applicant on August 30th?
We've received no further communication, as far as I understand, in response to our comments of the site plan review that was submitted to us.
So I have with me a long list that I'm not going to enter into evidence of the comments that were provided to the applicant. It was emailed to the engineer of record, Richard Kern, Honeycutt and Associates, on August 30th. And in that list, there are 19 comments that need to be addressed by the property owner and or her engineer in order to proceed with receiving a permit. This information needs to be addressed in order to get a permit. And it's, again, dealing with a property that's been improved without having a permit first to go ahead and do that work. Without going into the details of what has gone on that site, I know that the applicant is also here, and I'd like to see if there's any questions that you have from staff at this time, or if there's anything that I can further explain before we invite her up here.
Anyone have any questions at this time?
No, right now.
I don't see any.
Okay, I'd like to allow Ms. Lapone the opportunity to speak to the board, and if the board has any questions after her presentation, please let us know.
Okay.
Do you swear or affirm that the testimony you shall give before the board shall be the truth, the whole truth, and nothing but the truth?
Yes.
And for the record, you affirm your name is Leslie Lapone, the
Yes.
president of Lapone Enterprises, LLC, the property owner, correct?
Yes, that's correct.
Please proceed and direct your comments directly to the board.
Oh, thank you. Good afternoon.
How are
Again. There's no date on this, so I don't know when this was sent, because there's no date of the comments from staff. So I'm assuming, is it the 30th? I don't know, because there's no date on this document. So there's, 19 of these items that I need to address? This is ridiculous. I just got to say what I got to say. I'm being bullied, and I'm being targeted, because I believe, because I'm a woman-owned business, and I'm pretty close to being done with this and turning it over. I didn't want to go that way. I have worked and worked. I have tried. I have said, yes, I'm trying to fix this, and I've tried. Then now I get all this. You should see, I would like for you to actually have a copy of this so that you can see now what they're asking me to do on a property that is 0.43 of an acre. 17 trees, really? It's ridiculous. It's absolutely ridiculous. And I really believe that it's just an attempt to stifle my business. Every time I've had a meeting with planning, or I received comments back, we have made every attempt to try to address it. So what happens is, I come to planning, I would like this here. I would please help me remedy the issue in front of Code Board. This one thing. Then what happens is, I got 5 more things added on. So then I address those 5 more things. Then I've got 10 more things. Now I'm up to, as of the last, 19 more things. The pyramid base is getting wider and wider and wider. I mean, it's ridiculous. All I'm asking is you work with me that makes makes sense of this. This is ridiculous. And here's the part that's irritating me the most out of this whole thing. I've tried to work with them. I'm working with them. Everybody around me is doing what I'm not allowed to do. Yet I have to fix everything, but nobody else around me has to do that. It's not fair. I'm pushing now almost $10,000 in expenses on this project, on this, and I have nothing to show for it. Nothing. And I get letters like this, and then I have, well, I didn't get a response. Well, number one, I would like to know what the date of this letter is, because there is no date on it. And then back here on the very, very last page, pursuant to City of Titusville Land Development Regulations, 47-46, blah, blah, blah. I have 180 days to respond to staff comments. If I fail to respond within 180 days, by that date being February 26, 2018, then the application will be deemed withdrawn. I'm being made to sound like I'm not doing things, and I am doing things, and I'm trying to address items. But when you get a list of 19 items, and they're huge items, I can't address this in the middle of a hurricane, really? Come on. I'm very frustrated with this whole thing because I really feel like I'm being targeted. Will I address this? Yeah, Rodney and I, my engineer, will address it, and we're going to address it to the best of our ability. That it was not going to hurt my business, that is reasonable, and I know what's going to happen is I'm going to address it. Let me give you an example of the first line. They want a handicap and a motorcycle and a bicycle parking spot. Who goes to a golf cart shop with a bicycle? Really? I mean, I'm frustrated. I'm really frustrated. Anyway, will I address this? Yeah, I'm going to address it, and I can tell you what's going to happen. We will address these items to the best of our ability, and then planning will come back with a litany of more items for me to address, and it's just going to keep going on and on and on. And I don't know when it's going to stop. I don't know when they're going to stop throwing things at me. That's all I've had since the beginning. They just kept throwing things at me and throwing things at me. I don't know when it's going to stop. I don't know. I'm just really frustrated. I think they're really determined the City of Titusville is determined to put me out of business. I had a chat at the last, what was that, August 14th we were here, with the development person for the City of Titusville. And I said, hey, this is ridiculous. And no comment. But here's the comment that really irritated me. She said to me, I know the only important thing to you is about making money. That irritated me to no extent. And who was standing right beside me was Northern Economic Development, who had arranged for me to meet her. And I said to her, my people are important to me because I employ people. The people of this community are important to me because I provide a very valuable service. The money is secondary. That was the comment that came from her, and that irritated me to no end because that's not, that comes with good service. It comes with providing a good service. It comes with caring about people. For her to say that, I said, you know what? I really now believe the city of Titusville they just want to get rid of me. That's what they're trying to do. And anyway, I'm venting, but I apologize. Anyway, here's the bottom line. I've got this list of 19 items. Will I address it? Yes. My engineer and I are looking at it, and we're going to see what we can do, because until I address this, I can't move any further. I'm stuck in planning, and I can't move any further. Do I want this resolved? Yes, I want this resolved. I would have this resolved today, but I have to address all these issues. So that's where I'm at.
You finished with your comments for
I'm
now?
done. I'm done. I'm frustrated.
Board?
I don't know what else to say.
Board? Anyone have any questions?
I do, but I'm kind of concerned. The question would be either from the applicant or Mr. Parrish. To what improvements did you do when you needed the building permit issued?
What was done was have you seen my building?
Yeah,
Okay, so.
I don't miss it.
Okay. You're standing in front of the building. When you look over to the left of the building, we thought it was fine. We called it a pergola. At the time, we didn't attach it to the building. Our mistake was we attached it to the building. We shouldn't have done that. The reason we enclosed that area is because I had a very, very expensive golf cart stolen in the middle of the day. And when I contacted authorities, there was not much help that I was given in order to even make an attempt to help me recover that. So I said, I got to protect my property. I have to. And I didn't know what else to do. And that is one of them. That's the issue that we're talking about.
Okay, do you have any idea the dollar amount of that improvement?
I don't. I can dig it up and see. We did it ourselves. So it wasn't, we did it with our materials on hand.
Are all 19 comments about the pergola and its structure, or have you applied for more permits for other work as well?
I have applied for, there's also an issue, which I believe was removed from this whole thing. I have storage containers. Those storage containers, they want removed from the property. I agreed to that. However, I said, I will remove them, but my stuff needs to go somewhere. So let me go out this side of the building. Let me just build out in front. I went so far as not even to ask for a variance because I knew that was going to be an issue. I went to the very minimum I could in front. I went to the side. And that's part of all of this. And that triggered all of this. Believe me, it's not for lack of trying. I'm really trying here. But I can't do it and hurt my business. Because if you remember way back, this whole thing started, it wasn't just some anonymous call to code enforcement. The call came from a competitor of mine that is in the county. And they have been after me for 5 years in every way imaginable to try to put me out of business. And I'm not going to let them do that. So I don't know if that answers your question, but.
So you said the date that you were given to comply is by February 26th?
February 26, 2018.
2018.
Let me clarify what that is to the board. There are two timetables that are running here. One is code enforcement and our jurisdiction, and the second is planning regulations.
Yes.
The February deadline would be the time period in which everyone that applies for a site plan review has a certain period of time to comply, and if they don't, then the city throws the package away and you can start all over again. That's the way that works. You need not to be relying on that because you're on a timetable with code enforcement. That's what we're here for.
I agree.
And-
This date, I have to get everything done very shortly. I can't wait for this date.
And I have to make, just a comment, from my observations, some of what you testified today was the same thing that you told us back in August about trees and stuff. You're not responding in a timely manner.
This, I got August 30th, this is what the claim is. There's no date on this.
Okay. But you said the trees are on that. Well,
No, the trees are not on this one.
Oh.
No, trees
That
are,
was
oh
on-
no, this is a whole nother issue. These are all new issues here.
Okay. I would assume that that's in response to a proper site plan having
Yes, it
been
is.
submitted.
I submitted, actually Rodney did, my engineer submitted the site plan. The site plan was submitted in detail. Everything was on that site plan. For example, let me give you. The site plan was submitted in July. In that package were our hours of operation. We even actually submitted accident reports because there's an issue, we have an issue there as well. The drawings that were submitted triggered these comments. And for example, when I read this today, I thought, oh my gosh.
You just read that today?
No. I've been reading it extensively, believe me. On our site plan, there is one area that we have left open for green space. We're calling it's just a space. I read over here, we said, yeah, it's just a space. Well, now over here, now they want to know what the space is for. I'm like, really? I mean, really?
Did they actually remove the storage containers from this case? Are we only talking about the pergola, or are the storage containers also the permitting issue?
As what I understand, we're talking about the pergola as the storage containers were removed out of this issue, as I would deal with that through building or
Have you ever
planning.
talked about just getting a permit for the pergola and postponing the storage issue?
Doesn't work
I
that
can't
simple.
do it. They won't let me do that. I would love to do that. Just let me separate it out.
Okay.
No, the plan, when we originally submitted the plan, the site plan, which was properly submitted, I believe, triggered these new comments. And it's a big list of comments.
Any other questions? No other questions for you at this time. The city have something else that they need to?
Just to answer one of the questions that was raised just now, the letter that was submitted by the city to the engineer of record was submitted on August 30th, and I did follow up with Ms. Lapone, and I provided that information to her the following week on September 6th. Brad, could you come up here, please? Regarding the temporary storage containers, can you comment on whether the use of these temporary storage containers are currently allowed?
No, they're not permitted.
And should they be removed?
Yes.
Okay. Does the board have any questions about this?
Is that part of what we're deciding?
The site plan that's before you does not contemplate keeping storage containers on the site, so there's no reason for them to be there.
Well, it sounds like she has an expansion problem. Sounds like she needs more room than she has, and so she needs to site develop. But which she wouldn't have needed to do site developing for just the pergola. And it's really only on us to decide whether she had a permit for the pergola and whether she should be fined for not having a permit for the pergola. and whether we should perpetuate that and give her a date. But it just doesn't seem right to give her a date while she can't get through planning.
The improvements that are proposed on the site, including the improvements that have already happened on the site, including that outdoor fenced-in area, which is outdoor storage, which is also illegal in that zoning district, have to all be approved through a site plan. And so there has to be a development permit issued for all those improvements. Currently do not have a development permit issued for that property.
The appropriate process would be to submit a site plan prior to doing the improvements on the property and to get approval with a permit in hand prior to improving the property. And here, the improvements happened first, and the board has already made a determination with the finding of fact that a permit is required on this site. And the case is here before you to decide when that fine should start, if a fine is appropriate for the finding that you have already made. And I have, again, prepared a list of all of the times that this case has been before you, starting with August 6th, 2016 for the first scheduled hearing. It was continued in September, in October, in November, each time working on with Planning Department. It was continued again in December, and then in January, and then in February. For the first time, this case was presented to you on February 13th, 2017, and at that time, the board decided 3 months was an appropriate time to continue the case instead of just 1, to allow the applicant additional time to work with planning staff to submit the site plan and to get that permit in hand. In May, after 3 months, the property was found in violation for failing to come to terms with the city's code of ordinances. This board decided that there was an order to correct date of June 12th, 2017, and you reserved the costs with the opportunity to decide later if the applicant worked efficiently with staff. And if you look at that order to correct date, which I have done, and add 180 days from the day that you ordered this property to come into compliance with the city's code of ordinances, that date would be December 9th, 2017. And it is my opinion, and you can decide whether you think it's appropriate or not, to give the applicant 6 months from the date that you had previously set in order to correct date for that applicant to get a permit in hand by December 9th. And if not, to have a fine start running or to consider this case at your December board meeting. I think those are 2 reasonable options for you to consider with a reasonable period of time to get that permit in hand and to get this case behind us. The case was continued again in June, July, August. In September, we had Hurricane Irma, and we're here again before you today.
Any questions from board members?
So what you're saying is you want to give her until December?
It's up to the board to decide what you think is an appropriate period of time.
This is a recommendation from the.
That's my opinion of a reasonable period of time to get a permit in hand for this project would be that you could either set a fine starting in December or that you could continue the case to be reheard by this board to decide if a fine amount is appropriate at that time.
Can I say so moved on that? And
There's 2 options. You can't say so moved.
oh, I'm sorry.
I just feel uncomfortable setting a date, not knowing how she gets with planning.
Question period right now.
Can you testify to her cooperation with your planning department?
I can't, but Mr. Parrish can.
We have bent over backwards for Ms. Lapone for the past year, several meetings with her, trying to explain to her the process with her and her staff on several occasions. We've done what we can.
Are those 19 items that she's looking at the same items that you were working with a year ago?
Each time we get a new concept
plan.
or drawing sent to us, we have to review it based on what's submitted to us. The 19 comments that are for us now were based on the site plan that was officially formally submitted to us.
Have you seen anything done that complies with what you've asked for other than resubmitting planning?
We have not received a response back since we provided the comments to the applicant for her site plan. So we don't expect anything.
Over the long term?
The long term, have we seen any changes on the property? I'd have to speak with or leave that to the code enforcement officers to tell you what has changed in the property.
Well, is the planning department working with her engineer?
Yes.
And he's familiar enough to know what's going on.
Very familiar with our process.
Okay,
Yes.
so he's not like a young kid out of school not knowing what's
No,
going on.
ma'am.
All right.
Any other questions? Okay, thank you. All right, now we'll just open it up to the board. briefly.
Briefly, I have two things. I was informed on September 6th. I was given this on September 6th. When?
By email?
No, my dear, no. You are incorrect. No. No. My engineer had to go digging for this fine document online. I did not receive it on September the 6th. There was no follow-up. That's why I don't know about this August 30th. When is the date? This is what I've been encountering with this group over here. And this is now the third time it's happened. Oh yeah, I sent it to you. No, you didn't. Let me give you an example. When we were here on August 14th, which was a Monday, which was Code Board Day, there was a amount due for planning to review my site plan. I called Ms. Farrell and I said, hey, what's going on? Oh, it's $250. Okay, let me take care of that. No one advised me how much it was. On my way over here, I got a call, correct? You called me. No, I'm sorry, that's not the right amount. Did you already strike the check? I said, yes, I did. I'm sorry, the amount actually is $1,561.50 for the plan review. Okay, I'll go back to the office and I'll get you another check. This should have been given to me or sent to me when our plan was originally, when it was submitted the week before, and everything would have been paid. I mean, it's been a runaround. With all due respect, they have not bent over backwards for me at all. It's been one thing right after the other. Has been one more thing, and then I don't get the communications. I didn't get this. We had to go digging for this. Rodney did. He's my engineer. We had to dig for stuff. I had to ask, how much is, what's the 10:30 in the morning, the day of code enforcement meeting? Come on. We submitted the plan the week before. There's no been bending over backwards. I'm sorry. There's been none of that. You want to believe it? That's fine, but there's been none of that. Anyway, then there was no September 6th follow-up from over there. None. None. Just so you know.
All right, board. What would you like to do?
What I'd like to do is, I don't know if
Microphone.
I'm sorry.
What I'd like to see happen, and I don't know if we can do it, is just go ahead and continue with the continued violation, but give her until December the 11th meeting to have this all corrected, and also set a fine. If by December the meeting, if the fine, if everything's not corrected, it will go back to the fine will commence on, I believe it's the 6/12. Is that the time?
I'm trying to
The
set
date
a
that we would
retro.
use? June the 12th?
If this board is continuing a case for a period of time, I don't think it's proper to go back and go retroactive with fines. That's generally what we've voted, not to go retro.
Okay.
You know, if you place someone on notice that it's going to start in June, then that's fine and dandy. I don't have a problem. But if you come back 3, 4, 5 months later and say, well, we're going to retro back, I just don't think that's a proper way to proceed.
We'll have
Now,
the fine
if you want to
commence.
start a fine based on the December meeting, that's proper. You can start it as of today. You could start it next month. You can start it in December. Those would all be proper dates, in my opinion, because we have already found the property to be in violation, and it's not in compliance with the orders rendered by the board. So those I think are the correct options we have at this point as a board. Or you have the option to just continue the case at this point and let it go on for another month or 2 months, whatever the board desires.
I have a question.
Sure.
What if Ms. LaPone responds to the comments, the 19 current comments, which she says will probably generate other comments?
And she's probably quite correct, having been in the development business for a lot of years.
And
that's what's going to happen.
She has not responded to those new comments by the time the December 11th meeting. How do we proceed from that time? If we follow the city attorney's recommendations, how do we proceed at that time? Do we fine Ms. LaPone then, or do we continue?
Well, I think we don't have to set anything. We would just continue it and see in December whether she's made an effort. And then at that point, we could start the clock on a perpetual fine.
What you all need to remember, though, too, is that Ms. LaPone created the problem that's here right now by not following codes in the first place. And then, in addition to that, this case has just been going on and on and on.
I agree that she should receive a fine for not pulling a permit, but I just don't know if I should start the clock if she can't get through planning and development. That's my issue.
And I don't necessarily have a disagreement. I've been down this road just a few times.
So this will go on, could possibly continue down.
And why can't we separate the pergola? Why can't that be separate? That's what she did without a permit. Why can't we say, here's a permit for your pergola, and then why can't she do her site development?
The site plan is a requirement of the permit for the pergola or the fence.
Can she submit a site plan with just the pergola on it, receive that application, and then tackle this expansion?
Probably could have, yes. But that's not the path that's been chosen at this point.
They won't let me do it.
So, you know, she has an engineer of record whom I know and I respect and have used in my past, so I know that he's very familiar with the codes. Quite frankly, we need to establish a reasonable amount of time and get it over with. It's not that, and I'll go back to what I said, I don't object to the way the business looks. I think the business actually has improved from where it was.
I agree.
It was a derelict building and it's not now. That notwithstanding, you still have to administer the codes, whether you like them or not. And I, in my past, have had experience with the city on a smaller project, and I spent 2.5 years getting the permits through planning department prior to you being here, but I spent 2.5 years on it and was about as upset as Mrs. LaPone is right now. But eventually you get through if you persevere. So, you know, it's up to the board. I don't know whether you can read forward and say, yes, I want to start that fine in December, or you want to go ahead and extend this until December, but those are your only two options, really. You can either say, okay, let's kick it down the road for another 2 months, or kick it down the road and in 2 months from now there's going to be a fine starting. Again, there's 2 time clocks, just like you heard on the letter. There's a planning department time clock and there's code enforcement. Our concern is code enforcement. We're not here to rewrite the planning rules, whether we like them or not. That's what they are. It's her job to get past planning. If she doesn't like dealing with planning and you feel that you're being unjustly and unfairly dealt with, then I would suggest that you contact the city clerk's office, get yourself put on city council's agenda, because they, in fact, run the city manager that runs the planning department, not code enforcement. Code enforcement deals with codes themselves and whether you're in violation or not. Beyond that, we have no jurisdiction over any of these departments, nor do we want to have jurisdiction over them. That's city council's job to delegate that to the city manager, and then he's the one that runs the show. So that's where we are. We're on code. We've found that there is a violation of code, clear cut, and we need to go ahead and, quite frankly, get this thing down the road as quickly as we can.
So the question is, does the perpetual fine motivate her to move any quicker than she has so far?
Have no idea. That's a decision this board has to try and wrestle with. Well,
Are we all ready?
I don't know. You still want?
I will do the,
Wait. Oh, you want to make some comments?
No, I was going to agree with the city, but go ahead. I think you and I are on the same page.
Go ahead.
I hope so. I move to continue case number 16-89 relating to the defendant, LaPont Enterprise LLC, until our next scheduled meeting in December, which is December the 11th.
November.
No,
Our next one is.
December, not next meeting.
No, our next meeting in December. I'm sorry, not our next scheduled meeting, the next meeting in December, or our meeting in December.
The meeting in December.
The meeting in December.
Period. And that meeting will be on December 11th,
Yes, sir.
according to my calendar.
Well, I second that if you wait for one.
Okay. We've got a motion by Ed, seconded by RL. Any discussion? Roll call vote, please.
Member Richardson?
Yes.
Member Edens?
Yes.
Member Beckles?
Yes.
Member Grant?
Yes.
Member Monis?
Yes.
Vice Chairman Bell?
Yes.
Chairman Cunningham?
Yes, motion carries. Ms. LaPont, I'll go ahead and fill in a little something for your information. And I don't know whether it's going to be December or whatever time, but at some point, the board's going to say enough's enough, and they're going to assess it. They're going to put a fine on it.
I'm at enough right now.
Okay. So I would suggest, give Rodney a jingle and say, hey,
Oh, Rodney and I talk weekly.
okay. And he needs to get in and get it going, because I think the board's going to be running out of time with you. Okay, next case.
For the next case on your agenda was previously continued, case number 17-36, the property located at 712 Lucky Street. The city wishes to withdraw this case due to compliance.
Okay.
The next case on your agenda is number 17-108 for the property located at tax ID 2205926 Riverside Drive. The property representative, as you are aware at our previous meeting, the property changed ownership after the case was initiated, and you heard from a gentleman, Mr. Timothy Curtis, who you saw the deed that he no longer is the owner of the property. I'll call him the representative for that purpose. Mr. Curtis has provided to me, the city, a letter asking for this case to be continued. He says, Chelsea, this is Tim Curtis. I have a doctor's appointment that has been scheduled for quite some time with Dr. McShane in Titusville. At the same time of this board hearing, I would appreciate a continuance in this matter due to the circumstances of a medical condition. If you have any questions, please contact me by email or phone. Thank you very much. Given that information, I told the representative that I would present his request to the board for your consideration. I can go into further detail on this case if you would like me to, or you can choose to continue both this case and the following.
If the board has no objections, I'd like to move both of these cases to the end of our agenda.
Second.
Okay, I did advise.
I don't want to tie all these other people up.
I did advise the representative that if he completed his doctor's appointment to come to City Hall in case these cases had not yet been heard, so I think that's an appropriate motion.
Okay. Let's go to case 17-125 then.
Okay. For case number 17-125, the property located at 4261, this case was previously continued and the city wishes to withdraw this matter due to compliance.
Good work. Mr. Crisco. Good work, Mr. Crisco. You're closing cases out. That's nice.
All right. We've got case number 17-116 for the property located at 880 Forest Road. This case was previously continued, and therefore you have not heard the testimony yet. I have Officer Crisco here, as well as Carrie Beatty from the city's water department, to provide testimony regarding the nature of this case. I'll start with Officer Crisco and his testimony. Officer Crisco, have you had an opportunity to inspect the premises at 880 Forest Road?
Yes, the original inspection with the violation notice for non-payment of water was on April 24th. I did meet with the Mr. Harper, who is the deceased owner's son who lives there. I explained the violation as of that date. April 28th, Mr. Harper called, wanted an extension of time, which we granted. We followed it up in May, June. June 20th, he called the water department, wanted an extension because he didn't have a job and he was going to Social Security. So we continued it. June, July, and July 31st for the code board, I handed him another posting, advised him of the violation. Said he was still out of work and he should have a job. April 14th, he showed up at Code Board and we continued it another month because he didn't have the money and he was going to go to Social Security on a disability hearing. August goes by, September 25th, I posted it again for Code Board because of the storm. Again, talked with Mr. Harper, explained the violation to him. He says he's getting there. He'll get a paycheck soon. Mr. Harper called the water department on the 27th of September to say that he received a new job and he has another Social Security hearing on this date. He stated his new employer holds back 2 weeks on paycheck and he will be making some money. And he will contact us once he can make arrangements. He hasn't contacted us as of September 27th.
Thank you, Officer Crisco. And did you provide a notice of this violation to the owner of record by first class and certified mail, as well as posting the same on the property and at City Hall?
Yes.
And do you have the proof of mailing and an affidavit attesting to this notice?
Yes.
Please submit the proof of mailing and affidavit as to notice into evidence as Exhibit Number 1. And did you re-inspect the premises to determine if the property was in compliance with the violations as cited?
I will yield to Carrie Beatty on that one.
All
I'm
right.
afraid to deal.
After
The balance.
did you verify with the city's utility billing department that the property remained outstanding as far as the water debt and submit a notice of hearing and complaint?
Yes.
And do you have the complaint with you? Based
Yes.
upon your inspection, did you issue a copy of the complaint and a notice of this hearing to the owner of record by first-class certified mail, posting the same on the property and at City Hall?
Yes, it was handed to him.
And do you have an affidavit?
Yes.
Please submit the affidavit into evidence as Exhibit Number 2. Do you have a cost recovery statement detailing the cost incurred in bringing this case before the board?
Yes.
And what is the amount?
$480.70.
Thank you. Can you please submit the cost recovery statement into evidence as Exhibit Number 3? At this time, I'd like to invite Ms. Beatty up to the podium. Thank you, Officer Crisco. Good afternoon, Ms. Beatty. We are looking at the water account for 880 Forest Road. Could you please provide the board a statement regarding the past due balance that's on this account?
$4,925.54.
And do you have the information regarding the last date that a payment was received for this account?
The last payment was received on November 29th of 2012, and the amount is $73.30.
My own records and research indicates that the former occupant of this house has a date of death that's January 11th, 2014. And as Officer Crisco indicated, one of the heirs to the property, I believe his name is Mark Harper, is currently residing in the property of his deceased mother. And the city has not received any further payment since we initiated this code case. Is that correct?
That's correct.
Does the board have any questions for staff?
Yes, I do. And what date was the water cut off?
Microphone, please.
What date was the water cut off?
The water was cut off on January 22nd, 2013.
And costs continue to accumulate at this time, though.
Yes, sir.
What was the date of death, Carrie? 1/11/14. No. 1/11/14.
So when was she cut off before she died?
A year before.
So at the time of cutoff, it was a fairly large amount was owed on the account?
1 month.
At the time of the, yes, it's two months delinquency.
When it got cut off?
Mm-hmm.
And from that point forward, it's accumulated $4,000 plus worth of charges?
$4,900, almost $5,000.
And what was the amount at the time of cutoff that was owed?
The amount at the time of cutoff, let's see if I have that listed. $241.97.
So it's escalated from 200 and some odd dollars to over $4,900.
Yes, sir.
And Ms.
And
Beatty, are
the-
there liens on this account?
Yes, the property has been liened. I don't have the full amount. I would have to get with finance, but it does have liens.
I think this is what we were talking about last month that we met.
One additional piece of information that I gathered is from the property appraiser's website. You can see that the taxes for 2015 and 2016 remain unpaid in the amount of roughly $1,600, and that shows me that the property is not being maintained financially, and that in the future a tax deed certificate will result in the transfer of the property, at which time the new owner would be responsible for any past due utility balance in order to get that water turned onto that property. So the state of this property is that both taxes and utilities remain unpaid since the death of the former owner, and the property is listed in the property appraiser as the Doris E. Harper Estate, and the city is attempting to find a solution to this code violation by presenting the case to you today.
I'm sorry. There's nothing funny about that. You know, I'm sorry.
Questions from any board members?
Well, I would just say this is a clear case that we need to discuss as a board. If we're going to rule on this case, or we're going to suggest it be sent back to the city council to act on it. But the city council did, in a sense, act on it at the last meeting. Not this particular case, but it was pointed out by getting a copy of our semi-annual report talking about water off issues, that they will discuss it. They referred it to the city attorney, and they're going to talk about it supposedly at tomorrow night's meeting.
What could they possibly have jurisdiction to do? A welfare check? Or, I mean, I don't know that they couldn't foreclose on somebody's ownership or seize the property.
Seeing that the fines are increasing when it was only owed $200 and some odd at the time the water was cut off.
Well, and I don't think this is a case where somebody couldn't figure out how to work with them. I think they made a conscious decision to stop paying for this utility for the last 6 years.
Correct, but you also need to correct that terminology. That's not fines.
That's their utility service.
There's two different
That's their
things.
utility service availability.
Trash and
Yeah, availability.
stormwater.
Correct, but it's not a fine.
Plus $1,600 in back taxes.
That would be correct.
They have jurisdiction to control trash and stormwater, so you could, not pick up their trash. That's the option, so that they don't continue to inhabit the residence.
Well, they're not getting water at this point. That was shut off back
Right.
years ago. So the accumulation of about $4,700 comes from a monthly utility fee that's been accumulating every month thereafter, and I assume,
Ms. Beatty, does that amount also include the annual stormwater fee that would be assessed on the
I was just
property in
gonna say that.
January?
Yes.
Yes, it did.
And
because
it would also-
stormwater was on water bills at that point.
Correct.
And there would probably be late fees and cutoff charges that will also be included in addition to the availability.
Correct.
What are we hoping to see? That the fines don't reach a certain amount, and what's the relief at that point?
That's why we
It's up
asked
to
it to
them.
get on our schedule so that we could figure out how we felt about what was going on with this.
If it does change hands in a tax deed sale, it makes sense that the city gets their portion of this delinquency for the last 5 years. But again, we set a perpetual fine here, and all we're doing is making an investor pay for it, so that doesn't make
We
much
don't
sense.
set a perpetual fine on these kinds of cases. We can assess the costs, and I think we have done that in the past, but we have not been setting fines.
That's correct.
And in the case of a foreclosure, or a tax deed, either one of those people are going to look at what are the accumulated costs behind acquiring this piece of property, and they will accordingly adjust what they're going to bid for or assume when they get it, because the liabilities will be there against the property. If they don't look, then that's their mistake. It's a discussion that we need to have as a board, and I'm not sure it's one we can have here while we're having a case going through. That's why we had put it on the agenda for a special discussion at the end of a meeting. I don't know that it makes
If we're
much.
gonna determine something as a board about this concept at the end of the meeting, maybe we should decide this at the end of the meeting.
I mean, how much, is there a limit to where this could go?
No,
That's
sir,
my problem.
not in
That-
regards to the monthly charges, because that's per our ordinance. Once they've connected to our main, they've tapped into the main, then they will continue to have the regular fixed monthly charges
I
every
mean,
month.
we could be sitting here next year, October, and it could be double what it is now. The same cases could still be pending, or, because it won't be resolved. This person, it doesn't look like this person
The
is
only
going
way
to
to
pay this
close it
bill.
is to have it a vacant piece of property, or,
If
you know,
the
comply.
occupant
If the
leaves the
occupant-
property, then that would resolve the case.
Say again?
If the
I'm sorry?
occupant leaves the property and it becomes vacant, then it would no longer be a property that's occupied without water service.
And if they don't?
If they don't leave, but they pay the bill, that's another form of solution, where if they pay the bill, then the water gets turned on. If the property is sold,
I understand all that.
those
But
are different ways that we could come into
If they leave the
compliance.
property, the monthly
The
base
bills will
charge
still continue to
continues,
accrue.
does it not?
Unless the property is demolished and the services are removed from the property, then that property will continue to
A
bill.
never-ending story.
Now, wait a minute. So you're saying, if I'm getting this right, that if the property is vacant, there's no water on, the monthly fee keeps going?
Absolutely.
Because there's still stormwater.
If you have a tenant that moves out of a piece of property, whoever owns it.
You get a
It's
minimum bill of
responsible
$40 or
gets
$45 whether you had
the
your water
minimum charge
turned on or
from the water
not.
company.
That's why I like to refer this to city council.
But there's still services attached with water that they're not going to be able to remove from each other.
They can change the ordinance.
That's correct.
And what gets me is that this person seems to be in a dire straits from what you said about getting a job, not having a job, et cetera, et cetera, et cetera.
We don't know.
I know it's not relevant, and it's not.
Yeah, he
But we
indicated.
don't even know that that's
I know
correct.
that, I know.
He indicated he's trying his best, and that they hold back 2 weeks of pay, so he just asked for a little bit more time to get his paycheck to where he could come down and try and
I know-
establish a pay arrangement with us.
And if he makes a payment on a pay arrangement, you'll restore his service.
Yes, ma'am, I do work with them.
To pay off $5,000 in back utility costs,
And keep on going.
plus $1,600 in, well, it's not
Well, and
your,
who's the victim
Yeah,
here?
that's-
Who's not getting their money? City of Titusville, what overhead did they have to provide the service?
Until how long ago, when was the ordinance establishing this monthly charge? How long ago did that start?
Well before my
That was
time.
before me too. I apologize.
I would
yes.
presume decades.
You really? I don't remember it from years ago.
I don't either.
That would be a question for Sean
Because-
Stelter, most likely.
I'm just trying to
You
figure
know.
out when
It doesn't stop.
can it stop?
It won't.
Why do
It
we want it
doesn't.
to stop?
It's
We wouldn't want it
perpetual.
to stop, because then the investor at least compensates the city after, the property changes hands. She said this is a downhill slope, taxes haven't been paid in the last 2 years, probably on a third. A tax certificate will be sold, there will be improvements, and someone can compensate the city for the little bit of overhead they've had to provide services for the
I'm sorry,
last
but
5 years.
I still have a little smidgen of compassion left in me.
I do too.
For the homeowner.
All right, then
That's who we're
I
talking
think what
about
we're
here?
going to do is we're going to move this case to the end of the agenda. We'll go into some discussion.
Probably the next one too.
We'll call you
And then
when
we'll
we
go
get
from
back to
there.
the water issue.
He hasn't made one payment in 5 years, though.
This one.
That,
But he can, according to him.
Yeah, we'll
Okay.
I know we don't
We're
know
moving
that.
this case to the end of the agenda. Discussion's over. Next case.
On the next case listed, number 17-117 for the property located at 920 Kenilworth Court, I had previously determined that the city wished to continue this matter for 1 month until your next scheduled board meeting.
So moved.
Want to continue it again, you said?
I had previously determined that Kenilworth would be continued for 1 month
So continue next month?
until November, yes.
Okay.
Second.
I'm sorry, who made the motion?
a motion to continue.
Who made the motion to continue?
I thought,
So I said continue to November. I mean, that,
Okay. Pat.
whatever.
I didn't say a damn thing.
Pat and RL.
That was just,
Motion to continue case 17117 till November's meeting. Roll call vote, please.
Vice Chairman Bell?
yes.
Member Richardson?
Yes.
Member Edens?
Yes.
Member Beckles?
Yes.
Member Grant?
yes.
Member Monis?
Yes.
Chairman Cunningham?
Yes, motion carries. Case 17-118.
For case number 17-118, the property located at 527 Rock Pit Road, the city wishes to withdraw this case.
With compliance?
And the city wishes to recite the owner
Okay.
for changed conditions. The next case on the agenda for number 17-120, the property located at 805 Gilbert Street, the city wishes to withdraw this case due to compliance that was achieved on September 26th, 2017. I'm sorry, not to withdraw. I'm sorry. The city wishes to provide testimony that this case is in compliance after the order to correct date.
Okay, so we had an order to correct as of 9/11. When did they make the correction?
September 26th.
So you need a motion, right?
Yes, we do.
I'll do it.
Need a motion finding compliance and citing the date because there is a fine.
What date did you say? September what?
26.
26th.
Okay. I move that the board issue its order finding compliance in case number 17-120, finding the,
118.
oh, wait a minute, okay,
120.
No,
Oh, we are
excuse me.
120.
Wait a minute.
120 is
Stop.
correct.
okay. 120, correct, Sheriff?
Yes.
Okay.
Yes.
All right, back to the beginning. I move that the board issue its order finding compliance in case number 17-120, finding the defendant, Frank Toma and Teresa Toma, in compliance with the prior decision of the board issued in this case and closing the proceeding as of 9/26/17, which is past the order to correct. It is now in compliance.
Second.
Motion by Pat, seconded by RL. Any discussion? Roll call vote, please.
Member Edens?
Yes.
Member Beckles?
Yes.
Member Grant?
Yes.
Member Monis?
Yes.
Vice Chairman Bell?
Yes.
Member Richardson?
Yes.
Chairman Cunningham?
Yes, motion carries, so we're on case 17-121.
For the tax ID located at Gilbert Street, tax ID 2200887, I'd like to invite Officer Hutchings up to provide additional testimony for this property that was heard last month or previously by this board, and where this board decided that the property was in violation for both overgrowth and junk and debris. I have, again, Officer Hutchings here. Officer Hutchings, have you had the opportunity to re-inspect the property located at tax ID 2200887 on Gilbert Street?
I did.
And has the owner brought the property into compliance?
As of my last inspection, no.
What violations still exist on this property?
Overgrowth and debris.
Does the board have any questions?
What was the date of your last inspection?
The last inspection would have been earlier last week, just a simple drive-by.
Close enough, so it was past the date of, okay.
And this is a vacant lot, am I?
Yes, sir.
Correct. Okay.
Oh, yeah.
I think I remember that you used a yardstick. Did you? That's the one we used?
Yes, sir.
Yes,
Yeah.
I do remember that now.
All right.
All right, any questions, board? Who would like to make a motion?
I will. I move that the board issue the following findings of fact in case number 17-121 relating to the defendant Bula M. Posley, Bethel Estate. The defendant continued to be in violation of the following sections of the code and ordinances of the city of Titusville, section 1326 and section 12-23 on October the 9th, 2017.
Question. I'm sorry, is this a,
This is second reading.
is this a second reading?
Yes.
It's old business.
I move that the board issue its final judgment assessing fine and imposing
Wait,
lien.
we've got to get past the motion on that one.
Okay.
Okay, continued violation. All right, so we have motion
Yeah,
with
okay.
continued violation as of today's date. And the motion was made by Ashley, seconded by
I second.
Pat. Any discussion? Roll call vote, please.
Member Beckles?
Yes.
Member Edens?
Yes.
Member Monis?
Yes.
Vice Chairman Bell?
Yes.
Member Richardson?
Yes.
Member Grant?
Yes.
Chairman Cunningham?
Yes, that motion carries. Now we need the next one.
I move that the board issue its final judgment assessing fine and imposing lien relating to the defendant Bula M. Posey, Bethel Estate, based on the findings of fact issued this date, and that the judgment contain the following provisions. The defendant is assessed in order to pay a fine of $50 per day for the violation of section 13-26 and 12-23.
$50 per violation per day.
Yes, and $50 per day for the violation of, okay, as set forth in the findings of fact herein.
Need a date of commencement on the fine, which should be 9/11, which is our date.
Do you want to go retro, or do you want to set it for today?
We would set it to the date of compliance with the board's order, which would be 9/11.
Okay.
Under normal circumstances, we would do that.
The fine shall commence on September 11th, 2017, and shall continue until the code violation has been corrected to the written satisfaction of the code enforcement officer.
Second.
Okay, Ashley, motion by Ashley, seconded by Pat. Again, for clarification, $50 for each violation per day, commencing on 9/11. Roll call vote, please.
Member Grant?
Yes.
Member Monis?
Yes.
Vice Chairman Bell?
Yes.
Member Richardson?
Yes.
Member Edens?
Yes.
Member Beckles?
Yes.
Chairman Cunningham?
Yes, motion carries. Moving smartly along.
The next case on your agenda is 17-28 for the property located at 1517 Elm Terrace. It was previously continued. This case has not yet been heard by the board. I have Officer Tuggle here to provide testimony, and the homeowner is also in the audience. Officer Tuggle, did you have an opportunity to inspect the premises at 1517 Elm Terrace?
Yes, several times.
And did you find this property in violation of the Titusville Code of Ordinances?
I did.
And what was the nature of the violation?
6-56, permit required.
Did you? If I may start this case over a bit, I would like to get the board attorney to swear in our officer who wasn't here for the swearing in at the beginning of this meeting, please.
You swear or affirm the testimony you shall give before this board shall be the truth, the whole truth, and nothing but the truth?
I do.
Please proceed.
Thank you.
What was the date of the first inspection, please?
April 24th of 2017.
Ashley, could you go into more detail regarding the nature of the violation?
There was a fence installed on the property, and it is a 6-foot fence that goes all the way around.
Do you know when the fence was constructed?
I do not.
Okay. Do you know when the permit was issued? Let me grab that.
It was issued on July 19th of 2017.
And it was first applied for?
On May 4th of 2017.
Okay. So it sounds like your initial inspection was prior to the application for this permit being submitted to the city. Yes. Is there any special condition that's listed on this permit?
There is. The special condition is that it has to be a 4-foot fence in the front section. It can't be 6 foot.
So I'd like to have the board just focus on the issue here is the height of the fence. And there is a fence in place. There is a permit that was applied for and received. And the permit conditions state that the code requires the fence only may not exceed a certain height. And at the August Code Enforcement Board hearing, I met very briefly with the homeowner, and I explained to her that this case was going to be continued and so that she could pursue some options. I know that a variance was briefly discussed, and she may speak to whether or not she's going to pursue a variance for her fence. I'm not sure about that, but I do see that there is an expiration date on this permit that was issued. And Ashley, what's the expiration date of this permit?
January 19th, 2018.
And as you understand, the applicant has 6 months in order to complete the work that's on the permit. And so as we proceed, I would like you to keep that date in mind as perhaps the date of correction for this particular violation. And I'll proceed with the evidence here now. Ashley, did you provide a notice of the violation to the owner of record by first class and certified mail, as well as posting the same on the property and at City Hall?
Yes.
And do you have proof of mailing affidavit attesting to the notice?
I do.
Can you please submit the proof of mailing and affidavit as to notice into evidence as exhibit number 1? And did you reinspect the premises to determine if the property was in compliance with the violations as cited?
Yes, several times, to include this morning.
Okay, and did you take photographs of the property?
I did.
Would you like to display the photographs on the overhead?
That's the front side of the fence, which is actually the back side of the house. The owner was actually just explaining to me in the hallway that it was originally part of a separate property, and they split it into 2 different lots. So while it's the front, it's the street front, it's actually the back of her house. And that's the side.
Please submit the photographs into evidence as exhibit number 2. And based upon your inspection, did you file a complaint?
Yes.
And did you issue a copy of the complaint and a notice of this hearing to the owner of record by first class certified mail, posting the same on the property and at City Hall?
Yes.
Do you have an affidavit as to this notice?
I do.
Please place the proof of notice and affidavit into evidence as exhibit number 3. And do you have a cost recovery statement detailing the cost incurred in bringing this case before the board?
I do.
And what is the amount?
$410.26.
Thank you. Please submit the cost recovery statement into evidence as exhibit number 4. Before I turn over the podium, does the board have any questions of staff?
I have a question. So the regulation says you can only have a 4-foot fence, you can't have a higher fence?
In the front of your property.
In the front setback of the home, you can only have a fence at a height of 4 feet.
From the setback of the house forward. Most zoning classifications, 25 feet is a setback in the front. The front 25 feet can be no higher than 4 feet.
Why?
Because otherwise you'd have barricades
Fortresses
around every house
everywhere.
in Titusville.
Sounds good to me sometimes.
I'm sure it does, but that's the rules right now.
So forget the permit, so if she drops it 2 feet in the front,
She's in compliance.
she's in
if it-
compliance.
She would be in compliance of the special exception of the permit. So the only way that she could get anything beyond that would be through a variance. Now, whether or not it meets the criteria of the variance, for whatever reason that she may provide to the planning and zoning board, I don't know. But
Okay, all right. That makes sense.
If you have professional install.
Just so you all know too, one part of the code is that the good side of the fence has to face your neighbor, not you. That's,
No one to say that, I mean, you mean good side, mean the pretty side?
the pretty side has to face the neighbor.
Well, that makes sense.
No, it doesn't. How do you maintain a damn fence? How do you maintain that fence? How do you even put it up without going on your neighbor's property?
You ask your neighbor if you go over and paint it.
See, eventually the code comes back up and I get to say my piece about it each time.
I'm glad you were out there.
Would a
But
professional-
also with that, for the chairman's knowledge, is when you flip that fence around, it makes a nice step ladder for people to enter your yard as well.
Yeah.
I think the
So in this
chairman
case,
can
you were
make it-
saying, Ashley, that this fence is on the backside of the building that's built on that lot? Okay. The front side of the building is opposite of the picture I'm looking at. Is there a road on that side also?
No.
So the backside of the building faces the road.
What's the address part of it? What's the
The
address?
the address has to be assigned on the road frontage, and there's a formula in the
And it's
code.
based on where the mailbox is, correct?
No.
No?
No, it's, unless they've changed it, it's the property line with the least dimension that faces the road.
I have no idea.
There's a way of doing it. So how did,
In a builder, an installer is aware of the ordinance?
I'm sure the owner could answer that better than I could. I don't know who she had
An
hired.
installer
to
would
do
have
it.
pulled a permit. It's probably a
there was no
at-home
permit
job.
pulled, Laurel, to start with.
But a permit was granted, though, right?
A permit was
Eventually.
applied for after the fence was installed.
And it was granted with the special condition of.
Dropping the 2 feet.
Yes, it can't be 6 feet in the front.
I'm sure we'll get, after the owner comes up, we may learn a little bit more.
Okay. I love good comedy, I really do.
All right, any more questions of staff at this time? Hearing none, would the owner like to approach?
Still don't make sense to me.
Do you swear or affirm that the testimony you shall give before this board shall be the truth, the whole truth, and nothing but the truth?
I do.
If you will, please state your name for the record,
Jennifer Gagan.
and please direct your comments directly to the board.
Okay. And first, I'll just give you some background on the property. I purchased it in 2014, but after some research in terms of issues with this fence, which now makes light of why my home sits the way it does, it was apparently a mother-in-law's quarters to the address, which is 1450 Bell Terrace, which is on the, basically Park Avenue runs this way. There's Bell Terrace. It cuts back here and then comes around to Elm Terrace where I live. And it was the mother-in-law quarters to a home there. Back in the 60s at some point, it was split off, rezoned as a single family residence. At that time, it had a 6-foot fence around the whole property. When they rezoned it, when I purchased it, it had a carport and the 6-foot fence was enclosed other than where you pull into the carport. Fast forward to last year with Hurricane Matthew, the carport got tore down and the fence did as well with we had damages from that storm. So I did a homeowners claim and got the funds to redo the fence. So my friends and I rebuilt the fence. I opted to not rebuild the carport because it was just a pain and it just collects, I have a lot of pine trees and it just collects pine needles and rots out anyways. So ultimately that's where that fence came into play. It was put in at 6 feet because that's the fence height it was originally. I basically just put a gate up. So the reason that gate is there, I have some personal issues. I've had a gentleman, an ex of mine, who has stalked me, tried to kill me. He got out of prison recently and started bothering me again, but because he was locked up for so long, they did not renew my restraining order. So I have to wait for him to do something. So this is why my fence, the plan was to put a gate up, so my property is enclosed again.
If you don't get a variance, will you just hack off the top 2 feet?
I will be very disturbed by that because the issue I have with the variance in the 25 feet, it currently sits at 23 feet. The other thing is that is actually a half cul-de-sac, so the actual through traffic is not as much further than the easement where the 25-foot mark is. With that,
Stop for a minute. Your fence is 23 feet off the front? 23 feet setback from your front property line?
Yes.
So your variance would have to be for 2 feet?
Yes.
Just want to make sure I understood.
Yes. And the other thing is the utilities, the water thing is by my mailbox. There are no power lines there. There's no street lights. There's nothing for city utilities that they can't get access to. The power lines are on the back of the property, and they actually came out and accessed it through the neighbor's property to fix it when it was sparking and shooting flames out of it just recently. So those were some of the things that I was looking at for the variance to apply for that reason, because it is a half a cul-de-sac. The fact that it's the layout of the home that is the back of my residence. My neighbor who my house faces, my front fence, their fence is 6 feet, which comes all the way up to the street where my gate, past where my gate is, and it's 6 feet. But because that's their backyard, they're allowed to have it, and I'm not. But it sits on the street at the same spot mine does. And he just put up a new fence there also. So
I have a question. When you moved there, it was a 6-foot fence. Doesn't that
might help for her
over?
get a variance, but that doesn't have anything to do with us.
Right.
That's a good question.
But the new one wouldn't be grandfathered in.
But why not if it was already 6 feet?
Because once you have when the fence down, you then have to meet the current codes at the time when you apply for your new permit. So whatever codes are in place at that time, which in this case would be 4 feet in the front setback, and that's where she's at today.
Was there always a gate in front of the driveway?
There was a carport, but there was a gate that basically the carport was there. The gate ran to the end past there was a gate. It's hard to show you. I have a photo of.
Have you got a site plan? Did they make you put a site plan in at the time of permit?
This is what I had to give them. I had to give them this stuff here. I turned in this.
That's what I'm looking for.
Survey.
That.
And this. These are the actual, I photocopied the original ones from back in 1989.
Okay.
That I got from the original owner to show that it hasn't changed.
Okay, so what are we looking at?
So
What are we
this
looking at
blue
here?
part is the dispute.
I'm sorry, say again?
This is the road.
Yeah.
The blue
so
part's
this
the
is
gate.
the half cul-de-sac. The blue part is the fence.
The fence in question?
Mm-hmm.
And where's the
The
front of
gate.
your house?
The front of my house is here. My front door is actually there.
And was there always a gate across this drive?
It was not across the drive, that portion, it was across this portion. It's actually a Y driveway. So there's a driveway that comes up here and another portion that comes off here. The gate was here because there was a carport here.
So it's like a walkaway gate, not a drive-through
No,
gate?
it was a drive-through gate.
Oh,
It was a full gate, just like this one is now. So I just opted, because when those posts got torn down from the storm, to re-dig and put posts there, I have so many huge pine trees, I could not get through the ground. So we went forward and still couldn't get through the ground. I went forward again and had to go past the 2 big pine trees in the front in order for us to be able to dig down far enough so that my fence isn't going to fall down in a year, or when we have another storm like we did this year. As you see, my fence is still there right now. The other thing is the way the house sits. If for me to be able to pull into the driveway, I have just enough room where that gate is now where I can open it, park my car, and close it, which is why I put it that way. We literally shaved off every inch I could. I parked my car in, made the gate barely where it barely just misses it, and then shuts. Because I don't have enough room, because it's a pilot, I don't have enough room for a rolling gate to go this way, so I had to swing.
Is it automatic swing?
It's not.
You have to get out. You have to get out.
Yes, I have to get out.
Okay.
I have it set up where eventually down the road, when I have some more money, when we don't have 50 storms in a row and all these other issues in life, I do have plans of putting it. It would be much nicer to hit a button.
So it's also a safety issue for you too?
It is. The other issue is there with the elderly lady who lives on Park Avenue that butts up to this part of my home.
Overhead back on, please.
Yeah, right here, this property here. She lives, Park Avenue's over here. She was telling me that there was foot traffic through my property, through hers, to get to Park Avenue. Because where our street is, you can cut through my yard, go through her yard, and get to the main road. So she said there's weird people walking through your yard. There's kids cutting through to go to school, to their bus stop. So that is one of the other reasons I put the fence at the height it is, so that you can't just leisurely get over the fence. You actually have to try to get over the fence. So if you're on the property, you meant to do it. I went through and put lights up on top of every post. So at night, because the lighting's very poor there's only one street light on the other side, so you can't even see that turn in the road. We've had accidents there. Just a few months ago, we had a car that it was nighttime, it was raining, didn't see the turn, and drove through my yard and the neighbor's yard and hit a tree and had a lot of major injuries with that. So I put lights up on every post to illuminate the turn. I have reflectors to put on the fence so that you can see the gate better, because of this. I was just trying to go through all the things I can try to do to say, hey, this variance is justified, not only just for aesthetic reasons, but safety concerns, not only for myself, but the neighbors as well. Before I did this, I talked to all the neighbors, talked to every single one of them, and they all agreed with it. They all love the fence. They have no complaints with it before I ever did any of the stuff to repair it from the hurricane.
Just out of curiosity, you're saying that where you live now used to be a mother-in-law suite, and the property was divided, and you bought that. Do you have any idea when the property was built as a mother-in-law suite? Just out of curiosity.
Yeah, so I did some research, and it was built. So when you look at my property, there's a couple different dates of when it was built. So one says 55.
Okay.
One says 52, and then it was split off when I called the last time, and they said what they could find that are available records still in the 60s.
I'm just curious, do you have any idea when the 6-foot gate was installed?
When the gentleman bought it originally back in 1989.
Okay.
Yeah, the lady told me that the fence had been up for 40-something years.
Okay.
Do you have any idea when you might get a response for your variance?
Well, I have it. I have all the stuff. I haven't submitted it yet because when I called, they said, well, you're going to spend $500 and it's most likely just not going to get approved. I said, well, I need to do some more research before I just submit paperwork for $500 and you tell me to tear it down, which is going to cost me more money. Then I have to have a reinspection from the homeowners that already came out and inspected and said it was fine. So those are more fees incurred.
unfortunately, what will happen here is if you don't go into compliance or get issued your variance, we're going to be forced to find that there's a code violation, and then we're going to be forced to impose a fine and maybe a daily fine until it comes into compliance, because that's
Right.
really all we want is compliance.
Right, and when I got the permit, I was told that it was good for 12 months, but as they just told me it was 6 months, so I thought I had time. I'll research, do my homework, find out the laws, the things that qualify for variances, which I've done. I typed up I can give to you guys 7 of the points of why I feel like the variance would be okay, or at least they could evaluate it and maybe say yes.
I mean, I personally hope you get your variance, but we're
Right,
lost
I know.
years.
And so I was told I had 12 months from the time I obtained the permit, so I've been doing that. And then I got this notice for the
The
hearing.
permit is in fact good for 12 months, but if you don't get an inspection within the first 6 months, then it's going to expire. Then there's a
Okay.
problem. So and that's kind of a universal
Right.
thing
That
that I've
makes
run
sense.
into all over the place. If nothing's done, if there isn't one inspection within 6 months, then they
So
figure
I'll just
you're not
call
doing
them
what
at
you're
6
supposed
months
to
and
do.
say, come inspect
Can
my
you bring that
fence?
site plan up to me for a moment, please?
I don't know.
Because I can't tell from the overhead.
The gate, is that the only thing on that front facing, or would there be fence repairs and gate repairs if you were, okay.
Because the way the fence we did it.
Get in front of the microphone.
Oh, sorry. The way we did the fence,
That's the property line.
for structural purposes, we overlapped. So it's basically like a braided fence. So you have a full board here, a half, where 2
That's the
boards
front of
butt
the
up,
house.
and then a full board here, so that it doesn't flex when the wind blows.
the side?
Just out of
It's the
curiosity,
front, according to the city.
you do realize that when that house was built,
Mhm.
it was another city, Whispering Hills.
I wasn't alive then, so I cannot attest to what it was and wasn't.
I've heard it, as people say, some people say it was forcibly annexed into Titusville in 1963.
I would believe that to be true. It's been there for a while. From my understanding, the original owners owned multiple of the homes around there, but that was an empty lot, and they built on it, and then later down the road sold off all the other lots, and then eventually mine.
I'm ready to make a motion unless people have
So
questions.
I'm just going to.
And the other thing was, when I bought that house, I lived with my father down at the end of the street. That property was so overgrown with trees and stuff, you couldn't even see that. I thought that house was an abandoned apartment complex that nobody did anything with. I didn't even know it existed until it popped up on Zillow, and I seen it was for sale when I was looking for homes. So I've gone through a lot of work to aesthetically make the value of the home there more, and also clear out the property.
You've done a lot of research, and you should be commended for doing that.
Yes, I have. Thank you.
Earlier, when I asked you about where the fence location was with respect to the property line, you indicated it was 23 feet back.
If you measure it from the easement to that fence on there, where it says the easement to 25 feet back, it sits at 23 feet. Under the.
Come on up here.
Yeah.
What does this line represent?
So this is the end of my driveway. That line there is the fence, the
That's
gate.
Okay.
The gate.
This is 25 feet back.
Well, when you measure from what they quote unquote is an easement, it's 23 feet there.
Oh, I see what you're saying. No, you can't measure from there, though.
Right, so there's different, that's why I haven't turned in all the stuff yet, because I need more information in regards to, because there's things on the variance that I've read that says if you're a cul-de-sac, there's things that you can get variance for, the shape of your lot, all those play a factor into whether it would be approved. So,
The burden of proof is on you in a variance, and hardship and uniqueness are two of the things that are considered very much and weighted by that board, or at least they were in the past. At 23 feet back from the property line, you probably had a good chance, because it would be a 2-foot variance.
Right.
But essentially, I would have to advise you that your gate's sitting on your it's actually off your property. It's actually sitting in the right-of-way from what this drawing shows. And that makes it illegal in that respect also.
See, and that's why I am trying to get more information of what, because when I went and asked them about the variance, I had all that stuff. They said, you know, the easement is where basically I don't know what you call it, the drainage thing at the end of your driveway, the little gully. And they said, you know, the 25-foot, they showed me that. And then, but the layout of the property, like, this isn't my expertise. I save lives for a living, so this is all new to me. So it takes some time to find the research. It's not just you look it up online and it pops up on Google. There's 50,000 different counties that come up and their rules and things. So this is all my research. I've done my homework in trying to get to the point where I feel confident in turning in a variance.
Has the land been surveyed?
He's holding the
I'm
survey.
holding it.
Yeah.
That's the survey.
Okay, so is that a recent one?
That was from when I purchased the home in 2014. That's what I was
Yeah,
provided
recent.
with.
Recent enough.
But that's what
The
they gave
board,
me, and this is
this
the-
board is not going to be able to,
Yeah, no.
to give you an absolute answer one way or the other. But, you know, in trying to help you through the process,
Mhm.
you would be very unlikely to get a variance of 25 feet.
Right.
Very unlikely.
I understand that.
Now, if you can figure out a way to get back closer to what the setback would be, that has a chance of making it. But if you're basically trying to avoid all of,
And see, that was the thing that I had talked to them. I said, so there's multiple, there's applying for a variance, there's a vacation of easement, and then there's a vacation of something else. I have it in here.
yeah.
And I said, I don't
Since that's got
know which
nothing to do
one
with hearts
is appropriate.
and surgery, we'll say that that's,
Yeah.
might as well be talking Greek.
Right, so I said, I'm trying to figure out, hey, which one is more appropriate? Do I need to apply for the variance? Do I need to apply for the vacation? Do I need to apply for all three? Are there multiple issues that are with the gate being there? Like you're saying, the 25-foot setback, that was what I was told was the easement, or does the variance cover all of that?
Yeah, you're getting mixed up between terminology.
Yeah, exactly.
In my opinion,
Mhm.
you would be very, very hard pressed to get this approved the way you would like it. There's a possibility if you moved back further onto your property and got closer to where that 25-foot setback is, you might have a chance,
Mhm.
especially in light of all the history of it
Mhm.
and some of the hardship things. But as you heard from code enforcement, once the fence went down, now you're subject to today's rules, not 20 or 30 or 40 years ago.
Well, the fence got tore up, but I took it down. So
Can
it
I
wasn't
make a motion?
taken down.
Do you have any more questions or anything?
I don't have any more questions, no.
I'm
Does
trying
anybody else want to?
figure out and I've been in contact. I've called them. I've spoken with all the different people. I've been up here multiple times. I've done my homework. I'm getting all these things together. I'm working with them to try and do it with, to appease everyone.
I have, but not you to,
Miss-
y'all. If she's got the fence up, and that part of the fence didn't come down, are y'all saying she's got to move the fence back or forward? But how about the rest of it?
2 feet off the top.
We're not,
All we can say
I'm
is
just,
whether she's in compliance or
I'm
not.
trying to advise her as to whether to go try to spend more money to get a variance.
I know.
One is your application fee, and second is you need somebody that knows more about it than you do to help you through the process. And in my opinion, it isn't going to happen, so I would not advise you to. Maybe you can seek advice from like a land surveyor. and
I
you may-
fought for a variance for my driveway. I got it. I mean, it cost me money as well, but I got it. I think there's a chance that you could get it. I don't think I think it is low. He
Yeah.
was definitely in that field. He knows what the determining factors are.
Well,
But
and the reason I say that is because currently the fence sits on the right-of-way. It's not even on her property. So the first thing that would have to happen is that it would have to move back on the property.
So the whole
period.
fence would have to be moved.
Yes, yes, ma'am.
Which is a lot of money. That's why if it's cheaper for me to try for a variance than
Fence is out here
spending
in
money
the
to
right of way.
redo an entire
This is her
fence.
property in here.
So she'd have to move it back in 20 feet?
At a minimum, she would have to move it back because it's not on her property.
And that has nothing to do with code? There's no city code for that?
You can't build anything on the city right of way.
That's the other, there's a
But
vacation of
okay,
right of way.
I'm still going back to the original fence that's sitting there. That means she has to move that
She
one
needs
too?
to, she needs to go to planning and zoning or to, whatever that board is. We can't give her advice. You
No,
can't tell
and
her
that's
what
why
to do.
I'm looking
I
more for,
understand
that's what I need to know is who do I
What
go
you
to
need
talk
is-
to next?
I'm ready to make a motion.
What you need is a little bit more time to resolve this out, so I think we should, this is a case that we should just continue for,
Well, why don't we could
because we
just,
can't rule on this.
The permit,
There's too many-
we can
there's too
say
much-
that the violation exists, we know that exists, that's unquestionable.
Well,
And then we
okay,
can give her
this is the
till,
first hearing then,
Right.
right?
That's the first-
So we
that's the
can
first
find her
reading.
in,
That's the
in
first page.
finding of the fact.
The finding of fact, yes.
And,
and we can give her an order to correct by 1/19, which is when her permit expires. We can visit with her on 2/12 if it's not done yet, we can impose a fine then if she hasn't come in compliance.
very good. Why don't you take the
Do that.
motion and run with it then?
Do that one.
Right?
I move
You
that the
can
board
send this
issue
young
the
lady on
following
her
findings
way.
of fact in case number 17-28 relating to the defendant Jennifer Gagan. The defendant was properly notified of the violations as alleged in the complaint. The defendant is the owner of or in possession of the real property located at 1517 Elm Terrace, Titusville, Florida. The defendant is in violation of all of the sections of code of the ordinances of the city of Titusville listed in the complaint. I think that's the first part.
Second.
Okay, so Ashley and... Good. We have a motion and a second. Is there any further discussion? Roll call vote, please.
Member Monis?
Yes.
Vice Chairman Bell?
Yes.
Member Richardson?
Yes.
Member Grant?
No.
Member Beckles?
Yes.
Member Edens?
Yes.
Chairman Cunningham?
Yes. Motion carries. Next motion, please.
I move that the board issue its order to correct relating to the defendant Jennifer Gagan, adjudging the defendant to be in violation of the section of Code of Ordinances of the City of Titusville as determined in the findings of fact, giving the defendant until 9 a.m. on January 19th, 2018 to correct the violations to the written satisfaction of the code enforcement officer or to appear before this board at City Hall, Titusville, Florida on February 12th, 2018 to show why the cause of violations has not been corrected and why this board should not proceed to impose a fine for the violations. The board reserves jurisdiction to determine the costs incurred by the city of Titusville.
Second.
Second, very good.
Thank you.
It was Ashley and seconded by Pat. You were a little slow on the draw there, buddy.
Well, I'm always slow.
Any discussion? Roll call vote, please.
Vice Chairman Bell?
Yes.
Member Richardson?
Yes.
Member Edens?
Yes.
Member Beckles?
Yes.
Member Grant?
No.
Member Monis?
Yes.
Chairman Cunningham?
Yes, motion carries. Rick, you want to go ahead and unravel that one?
You have until January the 19th at 9 a.m. to correct the violation found by the board or to...
Turn your mic on.
Ms. Grogan, you have
Thank you.
until January the 19th, 2018 at 9 a.m. to correct the violation determined by the board. Or you need to appear before the board on February the 12th, 2018 to show cause why the board should not find you in continuing violation and subject to a fine of up to $250 per day. Plus, the board reserved jurisdiction for cost to determine later whether or not you should be assessed cost incurred by the city in the amount of $410.26. So it behooves you to continue your quest to try and figure out your problem. This board cannot directly assist you. They're just
appreciate
empowered to determine whether or not, up or down, you broke the rules or not. You did, you got to keep trying.
I got it. I got that part. I appreciate it. So I have a question though. Could someone maybe point me into maybe the right direction of who else I could talk to who knows more about
Well,
where to go from here?
I'd like to recommend that she meet with a planner of the day. Have you
Yes.
done that yet?
No.
Okay. If you just step outside these doors, you can talk to someone in the building department about, talk to the planner of the day. There's always someone on staff. If you don't want to do it today, it could be another day. And you can ask your questions, site-specific, about your property and the process that you would need to take, and they can give you advice as far as your initial steps forward and what you need to further look into before you make your final application for the Board of Adjustments and Appeals to consider your variance from the code.
Now, once I go talk to them and that stuff, if I file for the variance, does that change the date of the hearing?
The code board that you're before today has set a date that you need to comply with, and the variance board meets once a month, and so you need to get your application in before one of their meetings that would occur before January 19th if you want to get a variance.
Okay.
if you choose to go that route, that's fine. There's going to be a timetable that's attached to a variance procedure,
Which is why I'm trying to gauge.
which means that there's time going by.
You'll need to submit your application for a variance roughly 1 month before the meeting as your deadline in order to advertise for the item to be heard by that board. And so the meeting will be the last Wednesday of every month. You need to get it in by the beginning of a month you expect or hope to have your application heard.
And if you're disenchanted by what you find out, you can just bring the fence into compliance by that date.
Okay.
I think it would be more than cheapest.
Which is why I'm here and gone through all the research and because.
But the city planner can help,
Okay.
you know, and they'll give you an opinion.
Right.
Even
Well,
as
they
to
gave me this form that is basically that it says I waive my rights of the easement. So if they ever had to, the fence could stay like that, but if they ever had to get onto the property, they could take down whatever they need to without notifying me.
That's always true if you build.
That's a waiver of right for constructing your permit in the easement area where the city has a drainage easement probably, and if we needed to access or maintain our easement, then that's what you signed your rights regarding.
Oh, for the front line there?
That's my guess. I haven't seen it, but
The fence appears to be in the front easement.
Yeah, because I didn't sign it because I don't know what it is. I still have it.
It's,
So I don't know, that's where I'm kind of like.
you have a
doing the
complicated
yes.
little problem there,
Yes, that's the
as
story
you
of my
are
life.
recognizing at this point.
Nothing is simple. Just putting up a fence.
But good-
and
good
doing all
luck.
this.
Hope-
Yes, I
hope
appreciate
something works for
y'all's
you.
time today. Thank you. Thank you, guys.
new business.
No, got one more.
The next case on your agenda is number 17-130 for the property located at 4,000 Alpine Lane. The city wishes to continue this case for 1 month.
5 minutes, Mr. Chairman.
Yeah, minutes. I need a motion to continue.
So moved.
Second.
Who said so moved?
Ashley did.
Ashley?
Yeah.
Okay. Motion's been made by Ashley, seconded by Joe. Any discussion? Roll call vote, please.
Member Richardson?
Yes.
Member Edens?
Yes.
Member Beckles?
Yes.
Member Grant?
Yes.
Member Monis?
Yes.
Vice Chairman Bell?
Yes.
Chairman Cunningham?
Yes, motion carries. I've got a request to,
I hate to be longer, and you sit there with that baby that's not acting up.
is
She's only
there a
8 days
long
old.
case?
I don't know how long it'll take, but I was going to jump to them next in new business. This is number 136.
Let's go for it.
Okay.
Get their case.
So it's on the bottom of page 5. I have next up case number 17-136 for the property located at 2038 Russell Drive. Before I proceed, I would like to make a procedural cleanup of this item. I would like to amend one of the defendant's names that is misspelled in all of the documentation before you, and hopefully the owners will testify that the information I'm about to give you is correct. The actual spelling of Jesse's last name is Bonine. It is not Bonnie, it is Bonine. I don't know if I'm
Spell
pronouncing.
again.
Bonine.
Yes.
Oh, okay.
And so I would like to move that the board consider amending the complaint to reflect the actual and correct spelling as I've just described.
So moved.
Second.
Thank you.
Motion by Pat, seconded by Joe. Any discussion? Roll call vote.
Member Edens?
Yes.
Member Buckles?
Yes.
Member Grant?
Yes.
Member Monis?
Yes.
Vice Chairman Bell?
Yes.
Member Richardson?
Yes.
Chairman Cunningham?
Yes, motion carries. Does the owner have any objections to the correction? Okay, thank you.
Okay, so the case before you, I have Officer Tuggle here to provide testimony. Officer Tuggle, did you have an opportunity to inspect the premises at 2038 Russell Drive?
I did. The first inspection was on May 17th of 2017.
And did you find this property in violation of the Titusville Code of Ordinances?
I did.
And what was the nature of the violation?
At the time, it was 12-23 junk and debris and 13-73 inoperative vehicles prohibited.
And did you provide notice of the violations to the owner of record by first class and certified mail, as well as posting the same on the property and at City Hall?
I did.
Do you have the proof of mailing and an affidavit attesting to the notice?
Yes.
And please submit the proof of mailing and affidavit as to notice into evidence as Exhibit Number 1. And did you re-inspect the premises to determine if the property was in compliance with the violations as cited?
I did on June 14th of 2017.
And did you take photographs of the property under your inspection?
Yes.
And do you have these photographs with you?
I don't have ones from that specific day, but I have other photographs.
Okay, what photographs do you have from what date?
I have 3 from 5/17, which was the date of the original violation.
Let's take a look. And what do these photographs depict?
This is the inoperative vehicle.
Okay.
Yes.
What the heck is he doing in that car?
Comedian, huh?
And the tag on the vehicle, you can't see it in the overhead, but you can see it up close. It expired on December of 2016.
Do you have any additional photographs from any other inspection?
Yes, this was from 9/14. It's hard to see on the overhead, but close up you can see that it's still on jacks in the back, and then it's on ramps in the front.
Okay.
Do you have any photographs of junk and debris?
I do not. That was actually in compliance on the June 14th.
City withdraws the junk and debris violation that's listed, and we're proceeding only with 1373 inoperative vehicles prohibited. Do you have any additional photographs?
No.
Please submit your photographs into evidence as Exhibit Number 2. Based upon your inspections, did you file a complaint?
I did.
And did you issue a copy of the complaint and a notice of this hearing to the owner of record by first-class mail, certified, and posting the same on the property and at City Hall?
I did.
Do you have an affidavit as to this notice?
Yes.
Please submit the proof of notice and affidavit into evidence as Exhibit Number 3. And do you have a cost recovery statement detailing the cost incurred in bringing this case before the board?
I do.
And what is the amount?
$410.26.
Please submit the cost recovery statement into evidence as Exhibit Number 4. At this time, we will answer any questions you might have before I turn over the podium to the owners in the audience.
Is there a cost difference if you just consider that we're considering only the inoperable vehicles today?
No, ma'am.
For
Cars being repaired, reworked on? Can't tell?
I have no idea what the status is. I haven't had any contact from the owners, so I don't know the details surrounding the vehicle.
Any other questions of staff regarding the case at this time? The owners like to approach?
Ma'am, if you don't mind.
Oh,
Do you swear or affirm that the testimony you shall give before the board shall be the truth, the whole truth, and nothing but the truth?
I do.
And please state your full name for the record.
Megan McGuire.
Please direct your comments directly to the board.
We do have the car in our driveway, and it no longer has the cherry picker that you saw in the first photo, and the hood has been reassembled. The car looks assembled. It's operable. It's our choice. We're making modifications to it, so we're working on it, and it's a continuing process. As we get money, we purchase the parts and we fix it. When we got the first violation on May 17th, or it was probably the second inspection on June 14th, we thought we had come within compliance based on our interpretation of the code. The inoperable vehicle before had looked disassembled, so we had assembled it. We put the hood back on, the cherry picker was put into the garage. We knew that it was insured and had an active registration. I had not realized that the tag on the back of the car still had the 2016 sticker. I do have proof that it is registered right now until December of 2017. So that sticker isn't there, but I have that and I can submit it as evidence. So that what she is looking at is a printout from the Florida Registration Office. We looked the car up from the VIN number, and I'm showing pictures matching that VIN number to the car, just so that there's clear evidence that this is the car and with that tag with current registration.
Is there any reason why you don't just park it in the garage?
Yeah, our garage is full.
Like most of them in Townsville.
Yeah.
If that becomes the item that would just put you in compliance, would you just park it in the garage while you finished working on it?
Well, actually, under the
But if it's-
testimony, if it's a registered
If it's
vehicle
operable,
and it
just put the
runs.
sticker on. It says operable, it's okay.
Yeah, I did hear you say it's operable, right?
Yes.
Okay.
Is there a reason you can't put the sticker on the?
There is no reason, and we can. We just felt it wasn't necessary. We haven't gone down to the DMV to see why we didn't get maybe it was mailed to the wrong address, our current registration with the sticker. It hasn't been a priority because we know that the car isn't going to be driven for quite a while because we don't have the funds to fix it. So we've just been paying insurance on it, and come December on my birthday, I'll renew the registration again. And we felt leaving it in the parking lot, it just wasn't a priority to find that sticker.
You got other private stuff,
Ma'am.
right?
Yes.
Are
Yes.
these for the board to keep and look at?
Yes, that can be entered as exhibits. What I had realized while I was researching the city code of violations is that per section 13-77, storage of vehicle repair parts and equipment, that is a code violation that we also were not in compliance, but we had not been cited for it.
You're not cited for it.
I don't see that here.
Right. So
Don't mention.
we had left it on the jack stands up until this point. I have pictures of what it looks like today. The car has come off those jack stands. We had left it up because we have a 20-month-old toddler at home and we have a newborn. So these repairs are made as we find the time to tinker it, and it takes a lot of effort to bring the car up and down for my husband. So we thought we had made the car in compliance by reassembling the hood and removing the cherry picker. So we didn't think to take it off the jack stands. I didn't even know that that was a violation until I digged deeper into the city's code, because I don't read it on my spare time. So we have...
You don't?
No. So we have fixed that, though. Yes.
Where did this paper come from?
We printed that from the Florida. Can I ask my husband to come up and?
This printed from the DMV?
From the DMV website.
From the DMV website. It was printed from the DMV website. It's just showing that that's the VIN number and the bigger blow up is the VIN number, just matching. Yeah.
Tying the two together.
Just it's context.
Okay, yeah, I understand what that was. I was just wondering where you got this one, and this is saying that.
You turn on your mic, sir.
I was registered, it's just selecting that sticker on the back. Put that. I'm sorry. This is from the tag office, basically.
Yes.
Right? And the other two sheets are the vehicle identification number were shown here, and this is just the blow-up showing the vehicle identification to verify that we're talking about the same vehicle.
Yes.
Right? All you have to do is put that little yellow tag on a license plate, and we're done with it.
And is that true? I mean, couldn't you have a registered vehicle that's still inoperable?
Yeah.
Yeah.
Sure.
Yeah,
As long as they're paying the money to the state, they can stay in their driveway as long as they want, as long as they have a valid tag on a license plate. So I think all you need to do is put that tag on, and you will be in compliance of everything.
Okay.
Let's,
Wait a minute.
we're going to make sure that code enforcement is in agreement with that.
If the vehicle is operable, what is the question?
Didn't have a tag on it, didn't have a current tag on it.
It's currently registered.
Chelsea, do we still have a case or what?
Staff questions if the vehicle is drivable.
Exactly. Is it drivable?
You can drive it, the exhaust is off.
If we chose to drive it, we could, but it does not run well. It needs repairs to run efficiently.
That's not the point. If you can drive it from the mailbox to the corner, it's still drivable.
Right. We just choose not to.
Licensed,
It's registered?
insured.
I don't.
I think
If we can schedule a time for me to go out there and they can start it up and I can see that, yes, it does in fact run and it could move down the street on its own power, then yes, the case would be closed.
It's not safe to drive. It's not completely reasonable.
But it does run.
It runs. But, I mean, it's going to be loud. It's got open headers. There's modifications that need to be done to the car.
The code is only about.
I just don't understand.
Right? It has nothing to do with being registered.
If the tag isn't valid, then it's considered inoperable because you can't drive it down the street in the condition that it's in. So it does fall under that section of code.
And an active registration doesn't void the inoperable status.
That would, but I still, because of all the work that I had seen done on it, the cherry picker, the battery was out at one point, that kind of stuff, I need proof that it runs. This is the same we would require anybody.
Yeah, but
let me say this
the
also.
state does not have a vehicle inspection.
Ladies and gentlemen, we're conducting a proper meeting here. Okay. What did you want to say?
Oh, what I was going to say is that, like, when it was up on jacks and all of that, that can be a safety hazard because the car can just roll off of the jacks and that kind of stuff. So I don't think it's going too far because when she cited it, it was on jacks and had a cherry picker and all this stuff there.
Agreed.
So.
And I have an image that I took today of what the car looks like now. It has been removed from those jacks.
Right.
To
I understand that, but I was just explaining when it was cited at the time. It wasn't operable.
So, based on what we interpret as the definition of an inoperable vehicle, it couldn't be disassembled and it had to be registered and insured. We have completely assembled it. We have even taken it off of the jack stands, which we thought was a separate violation that we weren't cited for. And we have shown proof of registration and insurance.
It has to move on its own to be considered operable.
It can move, it's just not safe.
Okay.
One suggestion that I may have is that if the applicant would like to schedule an inspection with the officer, then they can meet at a later date and have a follow-up inspection because there was no opportunity for the officer and the owner to meet prior to this meeting date to see what the status is of this vehicle and if it runs and if it would meet the satisfaction of the code enforcement officer's determination that it is operable. I think that's what the code enforcement department is supposed to do. And if you would like to continue this case to allow a meeting, that is one solution. Otherwise, I think it's appropriate to make a finding of fact one way or the other. I think that the board needs to decide which is the appropriate course of action here based on what you've heard.
And if for some reason you can't get it running, we're not saying you have to get rid of your car, just park it in the garage. And then, you don't have to worry about those same.
I do understand, and I mean, we probably have to get a new battery, recharge the battery or something. It's been sitting for so long. There's steps that we have to take, and honestly, we don't have a lot of time, and we don't have a lot of money to do so.
Well, if it stays the way it is, we have no choice but to find it and enact fines, which will just cost you more money in the long run. And then if we get to a certain point, then it becomes daily fines, and it will just increase.
Well, I'm trying to come around this definition of inoperable vehicle, because when I had looked it up, it seemed like it was just that the car had to be completely assembled. So it is completely assembled. The battery is in there. If the battery isn't working, there's a little fine-tuning that we have to go through to be able to show them on the inspection that it's working. And it's a lot of work for us at this point in our life, and I don't think that is an accurate interpretation of inoperable vehicle. That's not how we're understanding that definition.
What's the verbiage in the code?
Well, I'm sitting here and trying to apply what's going on. At the time that Ashley made the inspection, there was a vehicle up on jack stands, hood off, this, that, and the other thing, and the tag was not correct. Now, if we roll that to today's date and we have a correct tag, everything's reassembled, can we reasonably believe that the inspector is going to drive down the street and determine that that's an inoperable or an operable vehicle? If
it starts and moves, that's why I was wondering what the code says. If it starts and moves, I would call that operable.
I think we're picking too hard.
Yeah, we are. I agree.
What's the code say for compliance?
Inoperable, if I may, Mr. Chair, briefly.
Sir.
Inoperable vehicle means any self-propelled vehicle designed for travel under its own power, which is dismantled, partially dismantled, discarded, wrecked, demolished, or partially demolished, or any vehicle designed for highway travel not bearing a current tag and registration.
Can we see her picture from this morning?
Why can't she just meet with the officer and let them make a determination?
I feel that's government.
Because we're not
oversight. We don't have
going to be
state
able to
inspectors.
see anything from here anyway.
Well, she says they say it's not going to start, and so that's not going to satisfy her, so it's not going to get us anywhere.
I don't think she said that, did she?
Well, sitting here talking about it's not going to get
They don't
anywhere
have a
either because we
battery.
don't know the status of the car.
Possibly, it could be a battery.
If I were to start it, it would create a noise ordinance at the very least.
Well, I think we could all tolerate that for compliance.
He's holding the baby.
She showed us, this is the picture from today?
Yeah.
No, I don't see any sense in
I
continuing.
can't tell whether it's assembled or disassembled or anything, really.
No, seriously. You want to do an initial finding of fact here? We'll continue this thing and get it down tonight.
Just let it continue and she can meet with her and they don't have to.
Okay. It sounds like we're going to start our debate unless there's anything else that you guys want to add in at this point?
We're finished.
Okay, have a seat, please. All right, open it to the board.
It's not like we're making them give away their car. Like, if they don't want to pay for the new battery and prove that it's operable, then park it in the garage. I don't.
Excuse me,
That's
sir,
her choice.
ma'am.
I mean, that's her choice. We just need to
Do you
continue
plan
and let them
on
deal with it.
restoring this vehicle as soon as possible? Is it your intent to make this vehicle operable?
Yes.
But not
But
as
not
soon as
anytime
possible.
soon.
I mean,
Excuse me?
It's fine for us sitting in the driveway the way it is. I mean, we own the vehicle, we own the property,
That's not fine for the city.
but it
If
looks
it's not ready.
fine.
You
I mean,
wouldn't
you
tell
wouldn't
from
even
any other
know
car.
if the battery's dead and you couldn't start it.
That's not what I'm asking here. Are you planning on making this vehicle operable where you could drive it?
Eventually, yes.
What do you call eventually?
They testified maybe next summer.
And I think
We
the
have
code
two new
is for
children, and
preservation
we don't
of the
make a lot of money.
neighborhood,
I would
so-
love the car to run so I could drive it to work every day, but that's not the case right now.
If it needs a battery, then can't you?
Well, it needs a battery, it needs exhaust, it needs parts to be safe.
It does not run well.
It runs, but not
All she
correctly.
wants to see is that it's operable.
You're not
Can you invest whatever it takes so that she can come do an inspection,
no,
say
I have
operable?
$100 in my bank account, and I'm on maternity leave. I'm not making any money, and we don't have time to clean out the garage to park it in there either.
What I'm getting at is that if all you need is a battery in the car to drive it to the mailbox and back, am I correct? Even though it makes a lot of noise, am I right?
It
That's
makes a lot of
all?
noise, but it's not safe, is what I'm saying.
That's not the point.
It is the point, though.
Well, not to me here. I'm asking, if you put a battery in the car, would it move?
No, not safely. That if I were to put a battery in the car, I could roll the motor over. Yes.
We're not asking to take a trip anywhere. All she have to do is
Drive
prove
down
to
the
her
driveway.
satisfaction that it operates.
Board,
We don't have state inspections for vehicles. I feel that that's adding
he's
more.
saying that he can't do it. I think the board needs to accept what he's testifying.
The reason why I was asking these questions is because I thought that if we could continue this,
Yeah, me too.
that you could resolve this, but apparently.
Just a moment.
Yeah, I will. All right, I'm trying to
Okay.
get to the city. The city would like to address the board.
Is this where we should take our 5 minutes?
No,
Or are they looking up?
no, they've got something they want to address this case on.
Mr. Chairman,
So, ma'am,
I'd like to read a couple of things from our city code. I have a definition of inoperative vehicle, which means any self-propelled vehicle designed for travel under its own power, which is dismantled, partially dismantled, discarded, wrecked, demolished, or partially demolished, or any vehicle designed for highway travel not bearing a current tag and registration. So if it can't self-propel itself under its own power and it doesn't have the current tag, then those are 3 reasons why it's an inoperative vehicle. But I'd like to also further read from Section 1373, the section that's before you today, which provides several exceptions for these inoperative vehicles. The first being a vehicle in the fully enclosed structure. We all know that a vehicle in the garage is safe. The second option is a carport that has an opaque covering made of either vinyl, nylon, chamois, or other similar material that is resistant to weather and is commercially intended to be used as an outdoor protective cover for a vehicle. Such cover shall provide sufficient screening so as to prevent ordinary viewing of any inoperable vehicle or its parts from adjacent public and private property. Number 3, vehicles stored or kept on the premises or property of a business enterprise operated in a lawful place and manner when necessary to the operation of such business enterprise, provided that any inoperative vehicles are stored in an appropriate and approved screened storage space, junkyard, or depository maintained in a lawful place and manner in the city. And 4th, any vehicle or off-road vehicle that is not in compliance with state regulations for street usage, but is in operating condition and intact, so that the vehicle does not meet the definition of inoperative vehicles provided in Section 13-56. So there's exceptions if it's covered, if it's inside a structure. The main section, though, that we are talking about today, I want to make sure everyone understands. It says 1373 subsection A, no person in charge or in control of any property within the city, whether an owner, tenant, occupant, lessee, or otherwise, shall allow any inoperative vehicle to remain on such property longer than 72 hours. No person shall leave any vehicle on any property within the city for a longer time than 72 hours unless the vehicle has a current tag and registration. Only one inoperative vehicle at a time shall be allowed to remain on such property during the aforementioned 72-hour period. So we allow the inoperative period of 72 hours, and then we'll do our follow-up inspection before we cite a vehicle under this section. There's exceptions that provide the owner an opportunity to cure his situation if he can't get the car fixed. If he can get the car running to the satisfaction of the code enforcement officer, this case would also be closed out. I would recommend that we have a meeting between those two.
I do have a car cover I can put over it if that satisfies it.
I'm not sure that does.
Not sure if a target.
I think that the meeting needs to happen between the officer and the owner at the property if a solution can be achieved under those exceptions, or if the car can drive. Those are two options that the owner has.
So is it proper for us to do a finding of fact, or should you continue it until a meeting can be done?
That's the board's decision. If you have found enough evidence to determine that there is a factual violation, if you don't find enough evidence before you today, then you can continue the case until you can hear more from the code enforcement officer after she's met on site with the property owner. She hasn't had a chance to do that yet.
Can I make a motion?
Go ahead.
I'd like to make a motion that we continue this case and give the officer an opportunity to meet with the owners, and we continue it until next month.
Second.
Second.
Okay, a motion been made by Gina, seconded by Pat to continue the case till our next regularly scheduled meeting. Is that correct?
Yes.
Mr. Chairman, 5 minutes, please.
Just a minute. Roll call vote, please.
Member Beckles?
Yes.
Member Edens?
Yes.
Member Monis?
Yes. Yes.
Vice Chairman Bell?
Yes.
Member Richardson?
No.
Member Grant?
Yes.
Chairman Cunningham?
No. Motion carries. We are going to recess for 5 minutes.
Candy.
10 more.
Piece of candy.
Okay, everybody, you can say whatever you want. Nobody wants to say anything here. Well, I will, because I've got some strong feelings about it too. Made the point that if I drove my truck home, parked it in my driveway, and took out the battery, would that be an inoperable vehicle according to the black and white of this ordinance?
Yep.
Yes.
72 hours.
Yes.
Yeah, you have
Yes, it
72
would.
hours with the tag and insurance.
But how is someone going to know that? How are you going to know that my vehicle doesn't have a battery in it and it won't operate?
Right.
And that's where I have a problem with this case.
Well, they didn't do that. They gutted it and left it wide open.
Okay,
Well, they'd be
but
able to tag on.
at this point, with a reassembled vehicle, not on jack stands, with a correct tag and insurance, how do you determine that that's an inoperable vehicle without going on the property?
The person who receives a notice of violation followed by a notice of hearing and complaint listing an inoperative vehicle as the code section cited for the purpose of the complaint and everything else involved has notification that they are required to call the city's code enforcement department for an inspection to prove compliance with the code enforcement section of the notice that was provided. And if the owners had reached out to the city for a compliance inspection, we could have had the conversation that I continued this case to have after this board hearing, because the owner did not communicate with the city what that status of that vehicle was, whether it was inoperable or not, because the city had not received any follow-through on the notices that were provided, and therefore we presume that the owner continues to be in violation.
I understand where you're coming from in that direction. But I maintain, sometimes we just tend to get too wrapped up in these things.
If at the beginning of the meeting, the conversation was as simple as the vehicle can run, and the officer said, okay, I'll come see it run, the case would have been continued and you would have heard no discussion. But there was a lot more of a factual dispute as to whether or not this vehicle can run, and I think that's why it got drawn out today. But if it was much more simpler, like the battery needs to get put back in, then the officer would say, okay, I'll come by on Thursday, and you can put the battery in on Wednesday, and the case will be closed after I do my inspection and see that the battery can temporarily run that car. And I think that there could be a really quick solution to cases like this if there's communication, and it comes down to a lack of communication, especially in this particular case where the owner needs to express what their intention is for the use of their property, where the use is somewhat questionable as far as whether or not our code allows to have driveways as the place of redoing an entire vehicle.
Should we assume that
Well,
there
I
was a
can assure
complaint
you-
made by someone?
Pardon?
Should we assume that someone somewhere made a complaint?
Probably.
And again, this
But
case...
you can go down the streets of Titusville, and they're not unique to Titusville by any stretch of the imagination. And I'm not going to try to beat it to death, but that's my personal opinion at this point.
5% of them are probably inoperable right now.
I guess I look more at the aesthetics. If it doesn't look like it's a problem, if it looks like it can run, who's it hurting?
The case was also started with junk and debris that was cleaned up.
That
and
they
the owner,
cleaned up.
And the owner recognized that there was a code enforcement violation by cleaning up the junk and debris and attempted to cure the inoperative vehicle. And hopefully by next month, this issue will be gone and this case will be closed.
Okay.
Because the ultimate goal of code enforcement is code compliance.
All right, let's go to case 17-133.
We're back up into old business for case number 17-108.
Yeah.
Okay.
If that's okay with everyone. The representative has appeared here at City Hall, and so the timing is now suitable to hear case number 17-108 for the property located at Riverside Drive, tax ID 2205926, which was previously heard in July, and the case presented with staff present to explain the alterations on the property located here on Riverside Drive. I explained to you at that time that the ownership had changed from Timothy Curtis and Freddie Curtis to Michelle, I believe it is Mack, excuse me. Michelle Mack and Freddie Curtis are the current owners, and we have Mr. Tim Curtis here as a representative to acknowledge the city's issues with this case. The city here has Preston Yates as the development services reviewer of this project, who has testimony to provide that there has been a pre-construction meeting and progress has been achieved for this case. And I'll invite Preston to come on up here and add his testimony to this matter. He has not been sworn in yet.
What is his name again?
Mr. Preston
Curtis?
Yates.
Say again?
Preston Yates.
Mr. Yates, if you raise your hand. Do you swear or affirm that the testimony you shall give before this board shall be the truth, the whole truth, and nothing but the truth?
Yes.
Please direct your comments when you answer the questions to the board directly.
Okay, Mr. Yates, did you have an opportunity to meet with the engineer of record for the property located at this tax ID on Riverside Drive regarding Mr. Curtis's application for the site alteration of his property?
Yes, I did.
And at the site pre-construction meeting, did you go over all of the engineering that was submitted to the city and find that it is in satisfaction with the city's requirements for our code?
Yes, it has been.
What is the current status of the permit that has been applied for by Mr. Curtis?
It is currently, we have received all of the documentation. We are in a process of having the plans stamped and approved, and the permit will be issued once the fee has been paid.
Okay. Has the final engineering been submitted by the applicant?
Yes, it has.
Okay, great. So there is a final component that is missing before the permit has been issued, but we are very close. Is that correct?
Yes.
Okay. So with that, the permit has not been issued, which is the substance that brought these 5 different violations before you. And although we are very close, the permit has not been issued for the site. I believe that it should be coming sometime in the next week or a couple of weeks. Would you agree?
Yes, I would expect to release a permit this week.
And with that knowledge, I would request to continue this case for 1 more month in order to get those permits in hand.
So moved.
Second. There is a
No.
representative in the audience.
Yeah, we've got to give him the opportunity to say anything.
I just want you to know that he's here so that he can acknowledge you. Are there any questions of staff before I turn over the podium?
Anyone have any questions? All right. Just have a seat for a minute. Timmy, you want to talk? What a crazy question. Ask if Tim wants to talk.
I got 5 herniated discs in my back I'm trying to deal with right now, and it's miserable.
Mr. Curtis.
Raise my right, swear to tell the whole truth, nothing but the truth, so help me God.
Me first.
Okay.
Do you swear or affirm that the testimony you shall give before the board shall be the truth, the whole truth, and nothing but the truth?
So help me God.
Proceed to the board.
I heard you say that, Preston, I'm sorry. I heard you say that there's a fee that needs to be paid. I thought I paid both. Let me take care of that right now.
Okay, we can.
Yeah, let's take care of that. What's the fee? I gave you 2 checks for.
Yeah, that was the review fee, but it's a fee.
Okay, well, what is the fee? Let's pay it right now. I can pull the rabbit out of the hat. Let's get it taken care of right now. How much is the fee? Well, better get here.
Mr. Curtis, if we could, let's get through this and then we'll.
Okay, yeah, let's pay the fee.
We'll
Let's
take
pay
care of
the
that
fee
on the
right
other
now. Give me
side.
my permit. And we can all be done right now.
All right.
Because there's a testimony I heard that we have a fee paid. I want to pay it, and we don't need to prolong this a month. Let's pay it right now. We're done.
What's the status between this and the next case? You got anything other?
I believe that the permit is related to, once the permit is in hand, then the next case would follow the same track as this one, where the material that's stored on site would be allowed pursuant to the permit that needs to be obtained. And so I would track these two
So we
cases
simply need to
together.
continue both cases so that he can
Correct.
pick up the permit.
Correct.
Let's do it.
Good?
So moved.
Second.
Well, what is the fee that is owed, President?
We can't answer that in this
We
room,
don't
but
know.
we can get
Okay.
it for you soon.
Who was the second on that?
Me.
Okay. Motion by Pat, seconded by Joe to continue both case 17-108 and 17-109 till our next regularly scheduled meeting. Roll call vote, please.
Member Grant?
Yes.
Member Monis?
Yes.
Vice Chairman Bell?
Yes.
Member Richardson?
Yes.
Member Edens?
Yes.
Member Beckles?
Yes.
Chairman Cunningham?
Yes.
What date will that be? Because I got some,
If you pick up the permit, you don't even need to be here.
The next meeting is November 13th. So you want to be in compliance by then.
That's just a housekeeping chore.
yeah.
If the
Okay,
permit
well, I'm
gets
gonna take
picked
care of
up,
that
then
with
we're going to
Mr.
close the
Yates.
case.
I'm gonna take care of that with him right now. Whatever we gotta do, I'll take care of that right now. I was unaware of, I don't, oh, there was a bond or something.
And what do you mean he doesn't? Well, yeah, he doesn't have to be
whatever.
here.
Okay.
Okay. But we reserve the right to submit the costs on this, right?
I guess we did, yeah. Which I'll assume that,
It's
since he's
ultimate-
doing everything he's supposed to do, that we'll get it all.
Well, and ultimately, he did do some work without a permit, so I think we did that for fact finding, right? But we just postponed issuing any,
To be honest, I don't remember.
okay. I just think, again, we were uncomfortable setting fine amounts, not knowing when the city would come around.
Yeah, we reserve costs, so the only thing I'll have to dispose of next month will be if he's picked up the permit, and then if you want to, if for some reason you want to assess costs, you can do that. But he's done everything we want. And the deadline was 9/11, but obviously with the storm, that didn't help much.
Right.
So we're just trying to get to compliance.
I suspect the next one that would be withdrawn due to compliance.
Yeah. All right. All right, we're still going to come back to 17-116 at the end of the meeting. So it looks to me like 17-133 is the next case.
If you wouldn't mind, I'd like to jump to 135.
Okay,
Case number 17-135 is located at the property,
what, do you want to leave or something?
for the property located at 310 Dixie Avenue, and I have Ken Hutchings here to provide testimony regarding this case. I'd like to invite him up. Officer Hutchings, did you have an opportunity to inspect the premises at 310 Dixie Avenue?
I did.
And when was your first inspection?
First inspection was 6/15/2017.
And did you find this property in violation of the Titusville Code of Ordinances?
I did.
What was the nature of the violation?
The first one was 1326. The following are 6-109. It's going to be 304-1, 304-18, 6, and 1. Mainly dealing with just the dilapidation of the building, the progressive degradation of the building itself.
I'm presuming that it's unoccupied?
Yes, sir, at the time.
What kind of infestation?
Rodent.
Did you provide notice of the violations to the owner of record by first class and certified mail, as well as posting the same on the property and at City Hall?
I did.
And do you have proof of mailing and an affidavit attesting to the notice?
I do.
Can you please submit the proof of mailing and affidavit as to notice into evidence as exhibit number 1?
Yes.
And did you re-inspect the premises to determine if the property was in compliance with the violations as cited?
Yes, I did.
When did you do that?
This morning.
And did you take photographs of the property?
I did.
Do you have them with you?
I do.
What date are these photographs from?
10/9/2017.
And what do these photographs represent?
The condition of the back.
On the overhead? You can put them on the overhead.
Yeah. That's the backyard.
Chelsea, before we go forward on our notice of violation, the attachment, does not list all the attachments
Turn your mic on.
6109-304.1, 1326, 304.18 are listed. The others are not.
The city will have to revise its complaint to remove a couple of sections from the complaint. We are moving forward with the 3 that are cited in the original notice of violation, which is just 1326, 304.1 general exterior maintenance, and 304.18, which is vacant unsecure. The other 2 will be withdrawn. Thank you.
Everybody up to speed?
Yes.
Okay.
If we could get back to the overhead, we've got some more photographs to show.
Okay.
This is now the condition of the exterior of the building, which I believe is still one of the violations that are remaining.
Yes.
Where are the dogs?
As you can see through here, water waking up, it's actually running from the bottom all the way up. And this is actual coming in all the way through that fascia board. There's a photo of the trusses and the truss ends, which back in the day, you can probably see it's actual structural member to supporting that roof. And this is simply another picture showing it on the front side of the house.
Please submit the photographs and evidence as exhibit number 2. Based upon your inspections, did you file a complaint?
I did.
Did you issue a copy of the complaint and a notice of this hearing to the owner of record by first-class certified mail posting the same on the property and at City Hall?
Did.
And do you have an affidavit as to this notice?
I do.
Please place the proof of notice and affidavit into evidence as exhibit number 3. And do you have a cost recovery statement detailing the cost incurred in bringing this case before the board?
I did.
And what is the amount?
$339.82.
Please submit the cost recovery statement into evidence as exhibit number 4.
Is this one of the properties that may be slated? Is this one of the properties that may be slated for demolition?
No, sir, not as of yet.
Okay, thank you.
Got a little rot, though.
Yeah.
Thank you.
Any verbal contact with the owner?
Yes, I messaged last week, Friday late afternoon, and I had spoke with him this morning. Said he's in the process of trying to make repairs, but it's been quite some time that there was no activity.
Did you make sure he knows he has to have permits?
Yes, sir.
So we don't have a subsequent case? If any board members have any questions, go ahead and fire away.
Was this the only, today was the only time you had verbal contact with the owner? Or did you have previous?
No, sir. He had called and briefly spoke with me, stating that he had made all the repairs. And
Put a beware of dog sign.
Ma'am?
He put up a beware of dog sign.
Okay. He did in fact cut the overgrowth, but not all of the repairs obviously were not complete. Put up a few fascia boards, put in some paint, and whether or not he's having somebody do it or he's doing it himself, I don't think he's aware to the extent of the repairs that need to be done to that house.
And nobody was living in it, correct? It's vacant?
At this time, no.
Is the overgrowth in compliance now?
The front yard is. As you can see, where the trash and the overgrowth, that is the backyard.
Yes, that's right. That's not the initial inspection photos, that's today.
Got a long way to go.
Any other questions? Okay. What would you like to do?
I'll make a motion.
Okay, Gina?
I move that the board issue the following findings of fact in case number 17-135 relating to the defendant Adiba Shuja. The defendant was properly notified of the violations as alleged in the complaint. The defendant is the owner of or in possession of the real property located at 310 Dixie Avenue. The defendant is in violation of all of the sections of the Code of Ordinances of the City of Titusville listed in the complaint.
Second.
Motion by Gina, seconded by Ed. Any discussion?
Yes, for clarity on the record, since the city withdrew, that is deleting subsection 304.6 exterior walls, rotten wood, subsection 306.1 infestation withdrawn.
Thank you, sir. Roll call vote.
Member Moniz?
Yes.
Vice Chairman Bell?
Yes.
Member Richardson?
Yes.
Member Grant?
Yes.
Member Beckles?
Yes.
Member Edens?
Yes.
Chairman Cunningham?
Yes, motion carries. Next motion, please.
I move that the
Chairman.
board,
My second didn't get registered. There was 20 microphones on at the time, so it was second on that.
Okay.
all right. I move that the board issue its order to correct relating to the defendant Adiba Shuja, adjudging the defendant to be in violation of the section of the Code of Ordinances of the City of Titusville as determined in the findings of fact, giving the defendant until 9:00 a.m. on November 13th. Is that the next meeting?
I think so.
Yes, it is.
Okay, on November 13th, 2017, to correct the violations to the written satisfaction of the code enforcement officer or to appear before this board at City Hall, Titusville, Florida on November 13th, 2017, to show cause why the violations have not been corrected and why this board should not proceed to impose a fine for the violations. The defendant is ordered to pay $339.82, which represents the cost incurred by the City of Titusville to bring this case before the board.
Second.
Motion by Gina, seconded by Ed. Any discussion? Roll call vote, please.
Vice Chairman Bell?
Yes.
Member Richardson?
Yes.
Member Edens?
Yes.
Member Beckles?
Yes.
Member Grant?
Yes.
Member Moniz?
Yes.
Chairman Cunningham?
Yes, motion carries. Next case, please.
Backing up one on your agenda under new business, case number 17-133 for the property located at 3308 South Hopkins Ave. The city wishes to continue this matter for 1 month.
So moved.
Second.
Who made the motion?
I did.
Okay.
And I
Ashley.
seconded it.
Ashley made the motion. Pat made the second. Roll call vote, please.
Member Richardson?
Yes.
Member Edens?
Yes.
Member Beckles?
Yes.
Member Grant?
Yes. Member
Moniz?
Yes.
Vice Chairman Bell?
Yes.
Chairman Cunningham?
Yes, motion carries. Looks like we're in case 17-137.
That's right. And I have Officer Hutchings here for this one. Officer Hutchings, if you'd like to join me. This is case number 17-137 for the property located at 1019 First Avenue. Officer Hutchings, did you have an opportunity to inspect the premises at 1019 First Avenue?
I did.
When was your first inspection?
First inspection was May 18, 2017.
Did you find this property in violation of the Titusville Code of Ordinances?
I did.
What was the nature of the violation?
Violation was 1326 and 1223.
And did you provide notice of the violations to the owner of record by first class and certified mail, as well as posting the same on the property and at City Hall?
I did.
And do you have a proof of mailing and an affidavit attesting to this notice?
I do.
Please submit the proof of mailing and affidavit as to notice into evidence as exhibit number 1. And did you re-inspect the premises to determine if the property was in compliance with the violations as cited?
I did.
When was your follow-up inspection?
This morning, 10/9/2017.
And did you take photographs of the property?
I did.
What do these photographs depict?
It depicted an unchanged area with the overgrowth and the debris. Coming out from one side of the road and the other.
Thank you. Please place these photographs into evidence as exhibit number 2. And based upon your inspections, did you file a complaint?
I did.
And did you issue a copy of the complaint and a notice of this hearing to the owner of record by first class certified mail, posting the same on the property and at City Hall?
I did.
And do you have an affidavit as to this notice?
I do.
Please place the proof of notice and affidavit into evidence as exhibit number 3. And do you have a cost recovery statement detailing the cost incurred in bringing this case before the board?
I do.
And what is the amount?
$339.82.
Please place the cost recovery statement into evidence as exhibit number 4. Thank you. And will answer any questions the board might have.
Have you had contact with the property owner?
No, I have not.
What are the rules regarding an empty lot and overgrowth? I mean, you could certainly buy a lot that hasn't been developed at all. So what rules govern what status it has to be in as a vacant lot?
If you're in a vacant residential lot, then you need to maintain that property from overgrowth and vines and all of those things that would be a nuisance to that residential neighborhood. And is this in a residential neighborhood?
Yes, it is.
Well, so like Rambling Acres has plenty of vacant lots that's full of trees and muck and brush, and are they really supposed to maintain those lots like that?
You know, I really don't know. I'd have to look backwards. If it's not been developed before, then I would say no, it can be in its native vegetative state. But if it's been developed, then I'll have to defer to the ordinance I'm not sure. In other words, raw land versus.
But it will also be up to the property owner to come and make a statement saying that they're trying to take it back to the natural state, or that they have it in a natural state if it's been already developed. If it's questionable. Still it's up to them.
I'd like to comment that no vacant lot is allowed to have junk and debris. And as far as the overgrowth, the allowing of many things, including debris, it goes on a long list: disease, dead, damaged trees to accumulate, or a dense growth of vines, underbrush, weeds, wild growth, or grass in excess of 12 inches from the ground to exist on any lot, tract, or parcel of land which is bordered by other improved property. So that's one of the questions, is where is it located? Is it bordered by improved property or a dedicated public street on at least 2 opposite sides? And provided that the distance between these sides from the lot and property lines is less than 250 feet. It goes on to talk about the distance and where it's located, but it's very much site-specific and where it's located. How far is this property located from another residence?
Just to the next lot, to the north, is a private residence.
And so if it's adjacent to a developed lot, then the standard, I think, is different from one in the middle of nowhere where no lots have been developed, to answer your question.
Although I think still probably in Rambling Acres, there's one that's at least adjacent to a brand new home that has never been cleared before.
And I think that's kind of the barometer. If nobody's gone in there and disturbed it, then it's in its natural state.
And this we
As
can
long as it
assume has
doesn't
been
have junk and
developed at
debris.
least once.
The condition described in this section along any improved property described in the city to the extent and in the manner that it constitutes or may reasonably become a menace to life, property, and the public health, the public welfare, creates a fire hazard, or provides a nest and or breeding ground for sand fleas, mosquitoes, rats, mice, other rodents, snakes, and other types of pests and vermin shall be unlawful and is hereby prohibited and declared to be a public nuisance. So in those scenarios where you're creating a breeding ground, then that's a property that's likely to get cited before another that's in a natural state that's not necessarily a breeding ground.
Very much up to the inspector and what he sees on the site. Any other questions? Who would like to make a motion?
I'll do it.
All right, Pat.
I move that the board issue the following findings of fact in case number 17-137 relating to the defendant Gertrude Brown. The defendant was properly notified of the violations as alleged in the complaint. The defendant is the owner of or in possession of the real property located at 1019 First Avenue, Titusville, Florida. The defendant is in violation of the following provisions of the Code of Ordinance of the City of Titusville. Section 12-23, junk and debris. Section 13-26, overgrowth.
Motion by Pat, seconded by Gina. Any discussion? Roll call vote, please.
Member Edens?
Yes.
Member Beckles?
Yes.
Member Grant?
Yes.
Member Monis?
Yes.
Vice Chairman Bell?
Yes.
Member Richardson?
Yes.
Chairman Cunningham?
Yes, motion carries. Next motion, please.
I move that the board issue its order to correct relating to the defendant Gertrude Brown, adjudging the defendant to be in violation of the section of the Code of Ordinances of the City of Titusville as determined in the findings of fact, giving the defendant till 9 a.m. on November 13th, 2017, to correct the violations to the written satisfaction of the code enforcement officer, or to appear before the board at City Hall in Titusville, Florida on November 13th, 2017, to show cause why the violations have not been corrected and why this board should not proceed to impose a fine for the violations. The board reserves jurisdiction to determine the cost incurred by the City of Titusville.
Second.
Motion by Pat. Who was the second?
Ashley.
Ashley. Thank you. I have no objection to the reservation of the cost, but I would maintain that since nobody's cared about it since May,
I know.
the odds are there's nobody that's going to care. Roll call vote, please.
Member Beckles?
Yes.
Member Edens?
Yes.
Member Monis?
Yes.
Vice Chairman Bell?
Yes.
Member Richardson?
Yes.
Member Grant?
Yes.
Chairman Cunningham?
Yes, motion carries. All right, so we have now accomplished
We have to go back
everything
to 116, the water
except
dispute.
the water.
And maybe we should talk as a board first and then decide on the case.
I would ask the board, just in deference to a staff member, does anyone have any questions of Carrie Beatty while she's here? Or do we need to keep her here?
I invited Carrie to return up to this chamber so that we could have a discussion based on the previous request from Mr. Richardson to discuss further the cases that have been presented to the Code Enforcement Board. And I know that Carrie does have a spreadsheet with her, and I would like to invite her to come up and speak to you all about this topic. And Carrie?
Is that what we have in our packages?
No, I don't believe you have a copy of it yet.
What's that matrix that we have?
I know that we have the one case yet to be decided, and before we go any further into the case that was previously discussed, I know there was a lot of different parts of the discussion that we had last month, and I wanted to make sure that we are on the same page as staff, as the board, and to answer your questions. And so the information that we have may be what you're looking for, and might not be it. And so I need you guys to work with us and help us understand what we can get you to, so we can resolve this issue. With respect to the comment regarding council looking into this, I know that there was a question asked by a council member at a previous council meeting for my office to look into a very particular scenario, which is similar to our case today, which is when a property owner dies and the property is left to the heirs, presumably, what happens to the water account at that address? And we've done some research and we are preparing to give council some feedback on that information, but that is limited in scope, not necessarily looking at what happens with non-payment, because there's a lot of different issues. There's the issues with who has title and ownership and the rights to be in the property. That's a separate analysis than has the property not been maintained and not been paid for and not been monitored financially by anyone who's continuing to own that property. And so there's different things that may be factors in why a property no longer has water service. And if you're just looking at who has the right to be in the property after the owner dies, and does the city allow the heirs to continue to reside there with water service, then that question can be answered differently than have you paid your water bill. And if there's an outstanding balance that's owed on a property, then that's a different question than who has the right to be there. And so there's a lot of distinctions that my office has been making, and that's why I'm prefacing this discussion with, we want to answer your questions, but we need to know specifically what the question is and what narrow focus am I focusing on in order to answer the questions that you don't understand. Regarding availability and the charges there, we could spend hours and hours talking about the rate structure that the city has and the analysis that we've looked into for years, how to create an availability schedule that provides water at an affordable rate. Because if the people who aren't using water service aren't billed, then the regular base rate would go up extreme. And Carrie can comment on that. Anyone in the Water Resources Department could explain that better than I could. But I understand that the rate structure factors in people who are not using it. And the bill is including base charge for sewer, your trash and recycling services, and together your combined utility bill does equal at least $35 a month that must be paid. And if it's not paid, then there's going to be an outstanding balance that will continue to accrue each month as long as that property is developed. Those are some basic concepts that are not the subject of this analysis today. And we could talk about them, but it's going to distract you. And what we're looking at is a property that's occupied without water service. And I need you to focus on just that issue, because otherwise we will be here all night. And I want Carrie to answer the questions specific to this issue. So what we have here is a spreadsheet that goes back. We have a database that's called CitizenServe that we enter our cases in order to create a code enforcement case. And for the active without water service cases, those cases get generated from the water department because they are the keeper of those records. They get turned over from the water department to the code enforcement department to initiate a case. And using that source of information, we went to CitizenServe to ask them how many cases were initiated under 6-109 where you have a violation of subsection 102.2, occupied with no active water source. So using that, we created this list, which we can go through each page and we can see the day that the violation was opened. And then the next column is the closed date.
Do you have copies for all of us?
This information just became available to me today, and so I can make copies for each of you, and I think that that's probably going to be the best way to do it, but I don't know if this is answering what you're looking for still. And so I need an affirmative from you. Is this what you want? Because I know you want information, but is this what you want? I don't know. So we have these cases that start in 2015. Let's see, it's 1, 2, 3, 4, 5. It's about 15 pages. And out of all of these pages, there's probably a dozen cases that have continuing open violations. Most of them are closed. And so that's what the majority of this information shows. It shows you the address and that all of these violations are closed and as of what date. And so I can provide this to you, but I don't know if this is what you're looking for.
We don't know till we've seen it.
And basically, you told us what to talk about. As an independent board, I think it's kind of up to us the way we want to discuss this.
Yeah, of course, but I'm trying to focus it, so you can go in any direction.
But that's your focus.
Let me summarize something for the board.
That might not necessarily be what the board wants to focus on.
If we looked at the cases, and I think where we've had our objections as a board is, and this is probably the class example, $5,000 hanging out, you know, like the rear britches got left open. Are we down to where we're only got about 5 or 10 more of these cases that are still boneyard cases that have been hanging around for years?
Well, and why did it take that system 5 years to tell us about it?
That's what strikes the board is, you know, we're sitting here and looking at a case now that's got $5,000 hanging out since 2012. Yeah, 2012, at which time there was $241 more or less owed, and now for 5 years it's accumulated a ton of money.
Although, arguably, what would change? If we'd have heard this in 2012 and we'd have imposed the fine and it stayed around not being paid for the tax certificates and stuff, what would it change?
But we didn't start getting it to the code board till what, this year or the end of last year?
That's the
We
point I'm
weren't
trying to
doing
get
any
to.
of
is
the, I
that
don't know how any of these cases all of a sudden started showing up at code enforcement in the first place.
What it is and what's been explained to me is that in order to move it down the line, a code enforcement violation helps to get the thing resolved? Isn't that what you explained to me?
I can tell you that I came to the city in 2014 and I was invited to participate in Carrie's collection team where we sat and had discussions regarding violations of water properties that had outstanding balances and what to do in scenarios where there was a collection issue. And as a result of my involvement, my participation with the city, we identified that it's a code enforcement violation in order to have a property that's occupied without water service. Mm-hmm. And so I know that I was involved from when these cases were first starting here at the city of Titusville. What happened before then I can't answer, but I can tell you that I was brought in to answer legal questions regarding collections.
We as a board are looking at a code violation which is based on occupied.
Right.
A vacant property
Doesn't
still
matter.
accrues the same monthly service charge, so to speak, for maintaining service. But our job is to look at what's occupied or not. That's the only thing that's getting brought to us. Now, how that exactly helps resolve all this is a real good question. And
Well,
of
at
course,
least there's incentive. Someone lives in it and hopefully they would want to bring it up to the minimal standard of living.
some people do, and there's certainly a cross-section of people that don't really care.
And you said that's 15 pages? What's the bottom line total for those 15 pages?
Well,
That's
that
the
would be.
thing. It doesn't have that answer. And I know you asked about a dollar amount, but that's not what Citizen Serve calculates. Citizen Serve calculates time and violations, but it doesn't give us the same information as what you're asking. And that's why I don't know that this is going to
The
answer.
reason that it came up at council was because of one address on this board semi-annual report. I won't name the address, but it says it's 000 daily fee and zero
And
current
that would
fee.
be correct information, sir.
That's correct information as far as this goes.
That's correct.
It is not correct as far as it's totaled over $5,900 in fines.
No, sir, it has not been fined.
Well, $5,900 in fees.
Past due fees.
And
Past
that's
due
what I say,
fees.
let's
Service charges,
distinguish
you mean.
the difference of what you're asking.
The city council didn't realize that it grew that much. I have a feeling that the 4 addresses here, the 3 that we discussed previously and the one we discussed today, I don't know how to put it better than that it's disadvantaged. And have we thought about referring it to somebody in social services to work with it? The resident owner, he's not the owner, but he's not a squatter. The next of kin that's living there with no will and testament, that he thinks he owes $300 or $400, but he can't match $5,900.
Well, she says if you take one payment, they will work with them and reestablish service.
I didn't hear that was the case in one of these addresses. that we heard 6 months ago.
I just remember she testified today that if they make a payment arrangement and they start making payments, that they do work with the customers.
Yeah, they put money up front. What we normally require is 50%, but we have worked with them at 25%. You know, that they put up front, and then we do a pay arrangement where they pay monthly on the pay arrangement and do not default on it.
How do we establish that they're the next of kin and not a squatter that we talked about?
In other words, take today's Doris Harper estate, and it's occupied by, I think the testimony was the son or son-in-law or whatever. The city's position, I don't think, can be.
You can't unless you speak with them and you get verification that they are, you know.
How do you verify that?
You have an application, if I remember correctly, now, Carrie, that requires the person to prove if they're a tenant, they have to have a copy of their lease.
Correct.
Or
Notarized document from the owner.
Who's dead.
Or a will.
Or, right.
And will doesn't exist in a lot of those cases.
And how long has that document been used?
Which document? The termination of service document?
Determination if they have a right to be in the building. I'm just curious as to how long that's been around.
Forms change regularly, so I don't know if we could answer that appropriately.
Well, again.
And if it's a relative of an owner that's deceased, we do not terminate their account, you know, right away because the owner's deceased. We work with, you know, the occupant at the property.
The relatives.
But we expect the account to stay current. You know, then we follow the proper procedures that we follow for everybody to keep it fair for all the citizens in Titusville, and that's our cutoff procedure. And that's where if they fall delinquent within 12 months, then the water will be cut off.
And
So,
then
but
also,
that's the reason why we do it, is to keep it fair for everybody within the city of Titusville. You know, that way.
Well, and everything we hear has been cut off because it's no water source. It's occupied with no water source. So we're not saying, we're not upset they're not getting cut off.
If it comes here, somebody's not paying.
And even though I can't logistically see how it would change anything, ideally we would all feel a little bit better if it came to us in the 3rd month and not the 30th month, so that we could do this.
I agree with you, ma'am. And the reason why it came so late is because I've only been in this office for so many years, and Chelsea and I have worked on so many different projects together. We have changed the ordinance in regards to meter tampering. We now have a $100 charge that gets added onto the account if we find that somebody has tampered with the meter. I have changed my whole process within the collections process. We watch it from the beginning of the cut. So once they are cut, it used to be that they only, and I don't mean to say this, but they really never looked at collections until the account was finalized. If somebody finalized their account and had a big balance, then they would try to look at that person, you know, to try and collect. Well, now my process is once the person is cut, then we immediately reach out to both the owner and the tenant over the phone, through letters. We reach out as much as what we can to try and find out what's going on, because somebody might be in the hospital or something like that. And then after that, we have a process which actually follows in line with our billing process. And we watch the charge through dates, and we do it within every 2 weeks. Every 2 weeks, then it goes from being cut off. We're reaching out to everybody, trying to find out what's going on. Then from there, if it's a tenant account, we terminate that tenant's account and put it active back into the owner's account with the water being left off. That way the owner then starts billing, because we can't find out what's going on, and most of the time the tenant has already vacated the property. So because we've had tenant accounts that we've seen go all the way up to thousands of dollars also, because the tenant never notified us they moved out, or the owner never notified us that they moved out, even though that's noted in our ordinance that we are supposed to be notified in a timely manner in regards to a change of occupancy.
Or we changed the ordinance.
Correct. We worked on that, and we changed the ordinance in regards to that to try and, you know, clean this up.
As of November 2015.
Correct. And then my next step that I was looking at within the process was in regards to meter pools, because we really didn't have a process on that. Whenever somebody gets cut off, and then we went back out there and noticed that their meter was pulled. Now I'm talking about years ago, before I even came here, there was never a process to go back out and look and check those meter poles. So now we do a recheck to go back out there and check those meter poles and make sure that they have no straight pipe and that nobody's occupying that property. And it's really to make sure that everybody's following the codes. And I'm sure everybody in the city of Titusville doesn't want, people living in vacant properties all throughout the city of Titusville with no water. So I've started that process. So this one that you're talking about, we did that recheck. It's actually called a check for vacant. We did the check for vacant back on October 21st of 2017. And we found out that there was no straight pipe. The meter was still pulled, but people were living there. And that's how it got to you.
So this was the first time you realized that someone lived
Correct.
there, and that's why it's
the
new.
first time since the meter was pulled back in 2013. And like I said, because I'm slowly trying to get everything to run the way it should in our department to where truthfully we could cut down on the delinquency and the breaking of the code.
And it's new now because they found a problem and then they found a way to fix it, and they made it code, and that's the way they're going to try to fix it, basically.
Historically, and this is a lot of years back, but water department and sewer department were they weren't run like they should be. We wouldn't even have a bill as large as it is had the sewer plant been built when it was supposed to have been built.
Mm-hmm.
Instead of costing $5 or $6 million, it ran $18 million because of departments. Joe's aware of it, and I am from years ago, of all the problems that were out there. So I guess really the bottom line that I'm learning more about now and trying to tie it together is that somebody's finally doing a good job and cleaning it up.
We're trying. We're going to be looking at other processes here in
But
the near future.
you got more baggage to clean up, is what you're saying.
Yeah, exactly. It takes time. We need the staff, and it's But we're actually, like you said, making progress. We've changed some ordinances, and I think we have made a huge difference already.
Okay,
But so this type
from the city's perspective,
Yes,
but
sir.
think about the son or daughter whose parent or whatever has died, did not leave a will. They come into Titusville, they have this house that's paid for, and they go down to City Hall and they say, how much do we owe? And get the water turned on. It's been 2 or 3 years since my father died, and instead of thinking that they pay a $300 bill, it's now a $5,000 bill.
Well, like I said, I do work with them, sir. I was allowed to do the 50% per Mr. Stoffer, the Water Resources
50% of the
outstanding balance.
Correct.
They can't even do that in some cases.
I have also taken 25% in the past, and worked with them in regards to doing a pay arrangement.
Joe, in order to perhaps address that concern, perhaps a policy can be established that you determine when a person passes away, and then try to figure out who's the relative and send them a notice before they get a $5,000 thing hanging out. And I'm sure these are kind of exceptions, but we're seeing all the exceptions, and that's what's got us in shock. But maybe procedure can be that way. I mean, it's not uncommon to have an availability charge for electricity or for water. And I can understand trying to stabilize it for the community. That does seem to make a whole lot of sense.
And I'm
the
thinking,
problem is the timing.
I'm thinking instead of you having to deal with the collections issue and negotiate a settlement so that they can have the water turned back on, and they realize every month they've got to add something to that, could it be turned over to somebody like Social Services?
I've attempted to contact the Department of Human Services, and they are not interested and don't have the jurisdiction over private residential apartments with this issue. I've tried.
You're talking about our Social Services Department, which was recently subcontracted out?
You mean the Neighborhood Services Department? No, I haven't talked to
It
Joe
was
Robinson.
Social Services as it was originally established.
I have talked to Neighborhood Services before that transition that just took place about a week ago. I've talked to them about finding
2 or 3 weeks ago.
It was the 1st of October.
I'm familiar with it.
And I'm happy that they have that, and it's great that we're doing that with the community. I think that's a great thing that we'll have to see going forward. But previously, yes, I've tried to talk to neighborhood services, and I have not found any solutions
I
there.
guarantee you they'll help you now.
Hopefully they will. And I will continue my search for assistance and trying to resolve these cases before they come before you, as I always have.
Based on some of the discussion and what we're talking about, though, we as a board do not have any jurisdiction whatsoever over this, other than if the board wishes a letter to be forwarded to the city council asking them
like
to
I
do
said
something
before.
or whatever, that's a possibility. But we're going to deal with this case and the merits of the case and the violation, and try not to be too much in shock about the amount. And I'm hoping that we're narrowing the number of the large cases that are coming to us. You're going to run out of them at some point, I hope.
Yes, sir. Yeah, because we started this new process, and of course, we're keeping up with it as we go. So now, all the meters that have been pulled, every 6 months, we're going to go out there and check and make sure that it's still vacant, and that, there's no straight pipe, because of course, they could also do a straight pipe and connect illegally.
But it's still, even if we hear it in the 3rd month, nothing will stop. They'll still provide service. They'll still have the monthly recurring. Nothing will stop.
Here's what would change
Till the
seeing these
30th
large
month.
numbers. If at the end of 6 months, after you pull a meter, at the end of 6 months and you go back for that inspection and it's not occupied, have some kind of a form letter that goes out to whomever owns that property, notifying them that every month there's an accumulating charge going against their property. So at the end of 6 months, you start that clock going, and we're not facing something 5 years down the line where they've got $5,000 or $8,000 hanging out.
But they still could. Even if
They could, yes, but that's,
But at
they're
least they've been
at least have been
notified prior to.
notified.
And you don't
Prior
think
to.
they know already?
No.
No, I
No,
didn't.
I didn't know.
I've lived in
I
this
own
town for
property.
40 years, and I didn't know that you had a monthly service charge on it, because I've never been out of water. I've always had an account.
Do you know you also have to pay taxes on your place? I know it's not relevant to this, but do you know that you still have to pay property
You have an
taxes?
obligation to maintain a property that you
$1,600
own.
This person owes in property taxes.
Well, they chose not to pay it, and they're going to lose the property.
Because they're going to go for tax.
And there was a notice sent out once a year on that.
Actual and constructive.
But, I mean, it doesn't hurt to notify somebody.
Yeah, I think that's where the process has slipped.
One thing I
Possibly.
would just comment on that is that the city does send a monthly utility bill to the address on record for the account, and if no one's getting the bill or the mail, and if we don't have any further address to send that letter to, then who is going to receive that information if the owner is in fact deceased and no one's
Good
getting
point.
the mail?
And they also receive delinquency notices.
But it's not properly explained to them.
But we do attempt
No, but they get a bill.
I know.
And
They get a
the
bill, but
lien
here's
is
the thing,
recorded in the
you
public
got a piece of
record that they're
property,
not
they say,
paying the water.
I don't owe this money, and you just.
But it's a bill that demands payment with a due
Yeah,
date.
well.
Yeah.
Along with the delinquency
Rummy, you
notice.
look
But
like
they
you
still
want
don't
citizens.
get it, they still don't get it that they owe money every month because the account is still open, it's still accruing, and they need to do something about it.
Again, this comes down to
Well, that's true, too.
communication, and if the recipient
how
of the
much they
letter
understand.
doesn't read it, then I don't know how the city can fix that.
Well, couldn't you put that clause in your application for water in the first place? And then they've been given notice that as they applied for water, there would be a recurring charge. I mean, I think it's got to be point blank obvious to anybody that.
We actually have the ordinance that we attach, and it's available to them, and they can have the whole ordinance that they want, which indicates everything.
99% of these people aren't paying because they don't want to pay, not because they don't know they owe it.
That's correct. Actually, because I just had a vacancy occur about 3 or 4 months ago. And then I received a bill from your department for,
$5,000.
no, I didn't get 5,000.
But here's knowing human nature.
But I have never experienced that in my 40 years in the city. And I've owned rental properties and personal properties. And this is the first time that I recognized that there was a maintenance fee, so to speak.
You should have a property manager.
You're applying for the job.
But that, because it came on board somewhere along the line, and I guess I've always had tenants and never had.
Pretty much what that fixed charge is for is to keep up with the integrity of our system. We don't collect with, any other way to keep up with that, with the integrity of it. We got thousands of feet of pipe of water lines, thousands of feet of pipe of sewer lines. Back in the old days, if a sewer line busted open, people were dying of diseases because nobody took care of it. We have to make sure that we take care of our system the correct way. And that's where that money is truthfully going. And it wouldn't be fair if, say, every person owned property in the city of Titusville, but they decided they wanted to live out of state.
They weren't sharing it.
They wouldn't have to pay for anything, but the one person who lived here in the city of Titusville had to pay to keep up with the integrity of that system isn't fair.
So in other words, you're enforcing something that has not been enforced.
Prior to.
Yeah. But you're
Not-
enforcing
not
it.
in a-
Only as far
manner.
as the occupied without active water source being
Yeah.
pursued as a code enforcement violation. However, the enforcement of the availability charges has always been pursued by the lien and foreclosure method of the city's utility billing collection.
At close of the account. They just never addressed it till close of the
It
account.
wasn't addressed at code board previously, but it's still a code violation that needs to be identified and cured by the owner.
And really what we would
Stormwater
love-
fee and all the other things that's recently been added to it in like the last 10 years, it's escalated that increase so high.
That's over on
Yeah.
tax bill now.
Well, it is now.
It is now, as of what, a year ago or something like that?
No,
Last
This year.
Yeah,
This is the first time?
Yeah.
Ah, great.
Just
I'm sure you get plenty of calls on that one. Or the tax collector
Yeah.
bill.
back to the letter after 6 months. As a way of being nice and as a way of at least getting the point across, if there could be a form letter sent out, I mean, I don't know how y'all system can set it up or something. Just say, this is to officially notify you. That way they've got it. Whether they remember it or not, that's up to them. But or whether they get the bill or not, but at least they'll know that this is going to be coming.
If they ignored the bills that have been sent
I know,
every
but
month,
at
I
least,
doubt that.
Does the tenant have to, does the tenant have to submit the landlord's
Again,
information for the application?
These are ideas that,
Yeah.
as
All
a
right.
board, we
Hear
might
that,
try to
I'm sorry.
suggest, but there are decisions that need to be made by staff and council, not.
Yeah, what in the world are we debating here?
We're debating why we're getting them, and I think we're seeing daylight at the end of the tunnel, and we're in shock about $5,000 accounts hanging
Yeah,
out.
we're in shock. I'm in shock also, but as you so fond to say, we had an objective to make.
Yes.
We are here to pass judgment on whether this person is in violation of the code enforcement.
And they clearly.
Yes, it's a huge bill, and it's going to get.
gonna get huger.
Can I use the word huger?
It's going to get huger.
Huger.
It's going to get huger because this person, in my mind at least, is obviously not going to pay.
No, the date of reckoning is going to be when they have a.
So what are we debating
tax
here?
sale.
Why?
I guess because we just wanted to understand it more.
Is there at
And how
some,
do we get there?
is there at some point,
It sounds like we're trying to force somebody to go out and hold somebody's hand and tell them, you better do this, or in 6 months, they could do this.
Yep.
Come on, these are grown people.
Carrie brought up a good point. Is there at some point, if they're not paying the water bill, at some point, did the Department of Health gets involved and say, this is a health violation?
That's what this case is.
I know.
Occupancy with no active.
I know, but I mean, is there some point that the state health department gets involved in all this?
They do, and if there's children, and if there's various things which you have to keep in mind. The code says they have to be required to attach to city utilities if city utilities are available. They have the health issue of that. But if they bring in water and they have a means of heating that water, the state health sometimes allows that to continue on through DCF and other entities. Equally, if they go and put in a well, then that too removes it from the city. So there's a lot of variables that we have to look at with each one of these cases.
Well, don't they have to have a permit to put a well in?
Yeah, you do.
Yes, needs to be
Nowadays they
approved.
do, yes.
And does the city give them a permit to put a well in?
No.
No.
All right.
Health Department.
Brevard County,
That's
Oh,
the
the health
county.
department.
Health Department provides it and
Oh, really?
Health
inspects it.
Department issues the well, and they also have it tested, and it has to be bacteria tested before they'll finalize it.
Is there a way that you could notify landlords? When the tenant applies, do they not include the landlord's information? Could you notify a landlord if it got exorbitantly overrun so that?
We've revised the code of ordinances to prevent tenant delinquencies from going beyond non-payment. And the account that Mr. Cunningham probably received a letter from was one where his tenant was cut off due to non-payment, and then the owner becomes responsible for the charges thereafter the tenant gets cut off. So the
mine was a case where the tenant left, turned the water off, and so I'm paying the monthly.
In that ordinance, we do not allow tenants to continue beyond non-payment as the account holder.
So we've got that covered. We just don't have heirs.
Correct. Yeah, and what we do on that is lien the property, but why we're here is because these are occupied properties with no water. It's not in regards to delinquencies and trying to collect. It's because somebody's occupying that property with no water.
They're identified after quite a period of time. That's why I think everybody, bottom line is the board's saying, why did we wait until it was up to $5,000?
And for comparison, I would like to just point out that the case number 17-117, which I chose to continue today, the reason I chose to continue that case today is because I would like additional testimony and evidence from the code enforcement officer that the property is actually occupied. He couldn't provide any additional testimony beyond the things in the driveway have moved around. He hasn't had an opportunity to speak with an individual. We know in the case 116 that there's a guy that says he's going to come in and pay the bill because he's living there. We have his testimony. We don't have that for 117. And so I like to make sound cases before I present them to you. And I like to make sure that we're, on the right footing before you make a decision. And if I don't see that the property is occupied, I'll withdraw it. I don't want to have any hesitation whatsoever before I present a case to you. And if it's not occupied, then I'm happy because I know that that house is no longer a code violation.
But it's not really about health and safety as much as it is collections.
It is about health and safety because as soon as that person moves out of the house, the code case is over. We're looking at people who are living in a house without water.
Let me ask one more question. Have you talked to the city of Cocoa and Brevard County? They have similar situations?
In regards, I don't believe, no, I have not. I apologize. I know that they follow their ordinances in regards to, cutting the water off once it goes past a certain point. I don't even think they let theirs go 2 months. I think theirs is 30 days.
Okay.
Once you're delinquent on that first bill that goes out, then they cut you
But
off.
I would encourage you to talk to Cocoa and Brevard County, Melbourne, to find out if they have similar situations and how they handle it.
Well,
Can I make a motion on
I believe it's
17-116?
17-116 is the case we have in front of us. I think that if there's no other questions, I'd like to proceed with that. And I guess I feel better that collections are being handled more aggressively because when this type of money gets collected, that will hopefully not cause our bills, the people that pay, to keep on going up.
It's like the insurance
Eventually
industry
it will.
all over again.
I believe it will. All right, so what would you like to do, Board, with respect to case 17-116?
I'll make a motion.
Go ahead, Ashley.
I move that the board issue the following findings of facts in case number 17-116 relating to the defendant, Doris E. Harper Estate. The defendant was properly notified of the violations as alleged in the complaint. The defendant's the owner of or in possession of the real property located at 880 Forest Road, Titusville, Florida. The defendant is in violation of all of the sections of Code of Ordinances of the City of Titusville listed in the complaint.
Got a motion?
Second.
That was Joe. My left ear works better than my right ear. Any discussion? Roll call vote, please.
Member Grant?
Yes.
Vice Chairman Bell?
Yes.
Member Richardson?
Yes.
Member Edens?
Yes.
Member Beckles?
Yes.
Chairman Cunningham?
Yes, motion carries.
I move that the board order to correct relating to the defendant Doris E. Harper estate, adjudging the defendant to be in violation of the section of Code of Ordinances of the City of Titusville as determined in the findings of fact, giving the defendant until November 13th, 2017 to correct the violations to the written satisfaction of the code enforcement officer or to appear before this board at City Hall, Titusville, Florida on November 13th, 2017 to show why the why the violations have not been corrected and why this board should not proceed to impose a fine for the violations. The defendant is ordered to pay. I do not have the costs for that.
$480.70.
$480.70, which represents the cost incurred by the City of Titusville to bring this case before the board.
Second.
Motion by Ashley, seconded by Joe. Any discussion?
I gave till the next meeting for compliance. Oh, 9 a.m.
9 a.m.
Any other discussion? Roll call vote, please.
Vice Chairman Bell?
Yes.
Member Richardson?
Yes.
Member Grant?
Yes.
Member Beckles?
Yes.
Member Edens?
Yes.
Chairman Cunningham?
Yes, motion carries. I'll give you a minute, but then board attorneys report when you're ready.
Okay.
We got everything. Do we need Chelsea? Everything got covered?
He's been
Yeah.
I do not wish to open up Pandora's box, but you are not covering the probate issue. And you're not going to be able to fix that because it's a private property right. When someone dies, the owner still has rights and it goes into legal purgatory. Many people choose to not commence probate or do anything because many of the occupants are poor individuals that are afraid of the law or don't have money or both. Those cases are just going to languish. And people, if they can, are going to be squatters and try and move in and take possession because they can. So there's still going to be a gap that's not going to be corrected by whatever you do except the passage of time.
Yep.
You don't pay your taxes, you're going to lose it after 2 years for non-payment of taxes. Then it'll change hands and it'll start over again. That's the solution. Up to that 2-year period, it's just going to languish. Because people don't want to touch it, or they don't have the money to, or they don't understand the probate process. Most people are not aware if there's no will, that is not a problem in Florida. It goes to closest next of kin if you die without a will. It goes to the closest blood relative. It does not go to the state. But if you file for probate within 2 years of death, all the deceased person's creditors have a right to get to the front of the line and say they want theirs before any family members get anything. So attorneys routinely tell people it's in your best interest to just sit on that case for 2 years to wipe out the creditors. So many properties are going to just sit idle for 2 years because it's in someone's pocketbook's best interest to do so. So there's still a hole that you all did not discuss, but that's okay. You can't fix it. Social services can't fix it. It's America. It's right to privacy. Back to business at hand. I have 2 cases to bring to the board's attention that I request the board consider turning over to the city attorney's office for their discretion in taking collection action. In both these cases are violations of subsection 102.2, occupied with no active water source. Saving that for last. The first case is 17-25, Sharon Harris Siplin. Defendant, final judgment dated April the 18th, 2017. Violation 6109, subsection 102.2, occupied no active water source. The final judgment did not impose a daily fine, as the city routinely recommends only the recovery of the assessed cost incurred by the city to bring the action to try and do the right thing, as they were trying to explain to you. The amount of cost assessment in 7-125 Sharon Harris Siplin estate, $409.51. So the judgment was for Cost assessment to date, 409.51. Next case, 17-26, defendant John Michael Rago. Final judgment dated May 23, 17. The first case, by the way, property location 415 Rock Pit Road, Titusville, Florida, Siplin. Rago, property located at 1824 Smith Drive, Titusville, Florida. Same violation, same issues. Cost assessment, $479.95. Both of these cases have gone to final judgment, have been recorded, have been of record for over 3 months. So statutorily, it is now the board's opportunity to turn it over to the city attorney's office. So now they have the hot potato to decide what to do with these judgments as to whether or not it's cost effective for the city of Titusville, which is really us, the taxpayers. Is it in our best interest for the city to institute a lawsuit to foreclose on the property over $400? That's their decision. I recommend you turn the cases over to them. Those are the only 2 cases I have for your attention.
So moved.
Second.
Motion by Joe, seconded by Gina. Any discussion? Roll call vote, please.
Vice Chairman Bell?
Yes.
Member Richardson?
Yes.
Member Edens?
Yes.
Member Beckles?
Yes.
Member Grant?
Yes.
Chairman Cunningham?
Yes, motion carries. Anything else on your report yet?
As to my report at this time, no. After the chairman's report is rendered, then I'll need to talk a little bit more.
Yes, sir. City Attorney's report.
Going back to 102.2 and Mr. Richardson's request previously, going back to the water discussion, I would like to see if your questions have been answered or if you would like a further report from Carrie's information that she presented previously. Is there more information that you need, and can I answer any of your questions?
Microphone.
No, I think it suffices, but just to give us a copy of that spreadsheet.
You want the 15-page? Okay, so just so you're aware what you're going to be getting, and you're not going to be, it does not have a column for the amount that's owed. That's not what this report is about. It's about the address. The violation is listed as 102.2. The date that it opened, the list started May 1st, 2015. There were no cases before then, according to this chart. And then it shows the closed date in the last column. And I will provide a copy to you. And in this document, there are certain items that have a case number that shows a lien amount that's associated with that address. And that's only on some of them, and I'd have to ask Carrie to further explain her notes on that, but that's Carrie's notes from some of those cases on there, and I'll get that to you with your next agenda.
Okay, sounds good.
Anything else?
That's all that I have, thank you.
Okay. Code Enforcement Manager.
No, sir.
Okay. All righty, Chairman's report. Well, I fully expected to be able to address my fellow board members at our last meeting. However, the weather interfered. Just want to let you know that it's been a pleasure to serve with you. This is my last meeting. I turned in, I just told them I did not wish to be reappointed. And this is the end of my term. So I thank you very much for all the time I've been here with you, and I wish you all the greatest of success going forward. I believe in the Code Enforcement Board and what we do for the city, and I believe in it very strongly, and I would urge you guys to really carry forward with it. It's a great service to the community and the people that are here. So that's the end of my report. I'll give it back to the chairman, to our board attorney.
Your bylaws indicate if you lose a chair or vice chair by resignation or termination of membership, which Mike is chosen to do, and if I may, I don't know that we're ever going to get a chairman that'll be able to fill Mike's shoes, ever. And that's making me think about a lot of decisions about the future, too. I'll leave it at that for now. back onto the law issue, your bylaws indicate in Article 3 that if you lose a chair or vice chair, then at the next scheduled meeting, you need to have a vote to replace the chairman. So next month's meeting in November, the board needs to consider the election of a chairman to replace Mike Cunningham as chair for the remainder of his term, which will end on January 2019.
Oh, that,
Yes,
I see what you're saying.
You're on a 2-year
Yeah.
membership term
Yeah.
that you didn't want to renew, but
I
your
didn't, right.
chairmanship tracks on a different timeline.
Right, okay.
So you're on January of every odd year to January of the next odd year. So
I
that's
see your
why
point.
your chairmanship's going to sit open until January 2019. So next month, the board needs to consider an election for replacement of the board chair. Not trying to influence your consideration, but your vice chair is Pat Bell. If you by chance choose to appoint Pat Bell as chair, just hypothetically, well, then you're going to have to consider at your December meeting, who will you select to be the new replacement vice chair? Because then the vice chair's position will be empty until January of 2019. So next month is going to be a big election for this board as to who will be your new chairman of the board. Now, in the interim, you have a vice chair who can serve in the absence of the chairman, but your bylaws indicate that if you lose one of your officers at the next scheduled meeting, unless you do otherwise, you need to have an election to replace the missing chairman.
So I'll start the meeting next month.
You will be the
Start meeting next month. and
vice
see.
chair serving as chairperson next month to run the meeting. But at the appropriate time, the board should consider the election of a new chairman. I'm talking in the abstract because November is my annual vacation month, and I will not be here next month. So I'll
Provided there's no hurricanes.
Well,
Regardless.
I'm not going to be here next month.
They don't
I
have
have
hurricanes in Puerto
commitments in other places that are very important to me at this stage in my life. So, sorry, you can fire me if you wish.
No, I'm not firing. Believe, no. I will be in your office
Well,
whenever you get back.
need to give consideration of the code board. I think the Titusville Code Board has and does and hopefully will continue to do an exceptional job. I think it's the best way to do it, to where people that are accused of violating the city code are judged by their peers. You all always bend over backwards to try and be fair, even beyond the issue that's pending before the board, as you have done today, trying to help people when that's not really relevant to the issues at hand. But I have kept quiet because I think this board does a good job, and unless and until someone admonishes me for not doing my job properly, I'm going to give you all leeway to do what you think is best when you're trying to help fellow citizens to figure out whatever their problem is, because you've done it repeatedly this afternoon. I have nothing further to report. If you have any questions, shoot.
I have a statement because I kind of look at it differently. I feel like we spent over an hour today addressing issues that we should not have been addressing. Some of the comments I've heard, like when the defendant was up giving testimony, oh, if you go by and look at the property, you'll see this, blah, blah. We can't consider that kind of stuff. We have to base everything we do on testimony and evidence. And it was like some people were up here giving defendants legal advice, telling them what they should do, and all the stuff that it's not part of our responsibility. And you're going on a borderline on being illegal, because we can't give legal advice to people. Let them deal with the code enforcement officers. That's what they're there for. I mean, because what if somebody does take your advice and they come back and said, oh, I couldn't get this variance and you told me to do this? Well, are you going to you're going to accept the liability for that?
Well, I don't know if anybody suggested that that's what she should do. We said you have two options. You can cut your fence 2 feet, or
but
you
it
can
went
get
a lot
variance.
beyond that. It wasn't just that defendant. It was about 3 people where sometimes it seems like people on this board don't understand what we're supposed to be voting for or what the purpose of being on this board is and what our obligations are as a member and what we are not allowed to do. It's almost like we need to be trained, and that's my position.
Other board member reports?
Just a question. How many of you are going to that Monday night thing that the city is sponsoring?
I RSVP'd.
I
Yeah. Are you aware of it, Romy? We have a dinner
I don't get out very much. That's all.
next
It was
Monday
mailed.
night.
An invitation was mailed for a thank you
Are you going to
dinner.
be there, Mike?
No. No, I doubt it. I'll be there.
Okay. I just was asking.
Okay. Hearing nothing else, this board is adjourned.